Yours? Sure. Yeah. I mean,
Yeah, I got that. I got it. So I'm waiting on one judge. Let me go down there. All right. You need some water. Oh no, we got a cooler now. Okay. I'll be right back. I guess we're copies. The issue will be. I guess we can wait till I get back to Judge Martin. All right. So just wait. All right.
Yes, how you feel this morning? Got a good holiday? Happy flag.
Which one? They won't. Yeah, seating in here. Seating in here. All right, thank you. Okay, all right. Sorry. Sitting in the middle over there.
I'm checking out. Still missing one. All right, bro. You still missing one.
Okay.
290.
We called him.
3 or 4 times.
He's called her, and me and Brian have called her also.
I'm gonna stand out there and wait, and just I'm gonna call her again. I'll stand and wait.
Post office will need to be on time. So
Right.
that figures his aspiration.
Go ahead, Brian. Hello? Hello?
My machine. I'll take it upstairs. I'll take it upstairs. How's this still missing one?
Yeah,
But next up, she want me to call her?
yes.
We'll see.
Hey, Tim.
She's still ain't answer. I think she's still ain't answer.
That's what I was just talking to the colonel about. Send somebody over there.
Yeah, send somebody.
Okay. Yes.
Who you see?
I need the address. Who? Okay, I'll text it to you.
So that's good. What's the lady name?
Yeah.
Yeah.
You got it?
We'll take it, Tim.
She got it.
I have the phone number, she's gonna ask me.
Okay. Hold on just a second. to get into that first. He want to come in and we'll get everybody started, and then we'll recess again. We'll take care of that.
Can you take a picture? Because it's...
Yeah, I'm gonna start the brown form.
All rise. Superior Court of Fulton County now in session. The Honorable Chief Judge Harold Glanville presiding. Court called to order.
Hi, good morning, ladies and gentlemen. Please be seated. All right, ladies and gentlemen, we're going to go ahead and take roll this morning. We're back on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. I'm going to just go ahead and take roll for the morning at this point. Mr. Stilwell, Mr. Botts, and Mr. Sharp. Good morning, gentlemen. Mr. Williams, Mr. Adams, Mr. Steele, and Ms. Renard, good morning. Mr. Kendrick, Mr. Apt, Mr. Hingerty, and Mr. Weinstein, good morning.
Good morning, Your Honor.
All right. Mr. Huey, Mr. Matthews, Jr. and Sr., good morning.
Good morning, Your Honor.
All right. And Miss, you have another counsel with you, Mr. Huey? Good morning, madam. All right. And Mr. Nichols, Mr. Harvey, Mr. Garner, Ms. Westmoreland, good morning. And Mr. Ryan and Ms. D. Williams, good morning. All right. All right, counsel for the state, ladies, Ms. Love and Ms. Hilton, Mr. Brown and Mr. Smith, good morning. All right, counsels, we are at this point in time waiting for one juror that has still not been able to be located. I have asked our sheriff's team to go ahead and see if they can find her, and that's what we're waiting on at this point in time. So we're going to just be in pause or in recess until that time comes, and then we'll go ahead and get started once our juror gets here. Okay? So we're going to be in recess probably until I get some more indication on what our efforts are to locate that juror. So we're in recess at this point in time. You can recess in place at this point, okay? All right. Let me make a couple of announcements while I'm still on record for our folks here in the gallery, our embedded media, all right? You are welcome, and we appreciate your the full and free and fair press and the benefits of the First Amendment. I would just ask you respectfully to remind you, and I know you all as seasoned journalists know this, do not take pictures of our jurors. Do not try and intercede or try and talk to them in any way, and that goes for anybody else in this courtroom. The jurors are not to be tried to be interfered with in any way or tried to talk to or anything. I know you all know that, and I know you all won't do that, but just so we kind of are all on the same sheet of music. If you have photographic or other equipment, I'd ask that you put it on your silent mode. Some of you have shutters that I can actually hear, so if you could change the setting on those, that would be great. And the last thing I'd just tell you is just please go ahead and within the dictates of your Rule 22, please go ahead and just follow that. If you have any questions, you can certainly ask me at the appropriate time, but all of you are welcome. Okay, all right, so we're going to be in recess until I find out more about whether where our juror is, and then we'll go ahead and get started. All right, so we're in recess. All right, Deputy Ingram, I understand all of our jurors are here at this point in time. Is that correct?
Yes, sir. Madam President, count for.
All right. All right, if we could summon our jurors for us, please, and Deputy Ingram, if you would have them, as we talked about earlier, not everybody except the last row?
Gotcha.
Okay, all right.
Hey, everybody.
Is everybody here, everybody present?
Mr. Sharp is coming in here.
All right, well, okay, I'm worried about him right now, okay, but, all right.
Hi, neighbor.
Don't send the last thing.
Our jurors present, count for.
All right, ladies and gentlemen, please be seated. You got no chair? Okay.
Need no chair. Need no chair. Yeah. Get him down there, roll. Get back, roll. Yeah. That was coming out.
Okay. All right. All right, all jurors present?
Yes, sir.
All right, okay. Good morning, ladies and gentlemen of the jury. Oh, come on, that sounds so lame. Come on, all right, let's try that again. Good morning, ladies and gentlemen. Good morning. Oh, much better, much better. Ladies and gentlemen, as you know, I'm Chief Judge Earl Glanville, and I'm presiding over the trial of this case. And at this point in time, I'm going to introduce my chamber staff. In the courtroom, I have my court reporter, Miss Christina Weaver. She's my official court reporter. And then to my right, your left, is Miss Violetta Omana, who's my judicial assistant. To my left, immediate left, is Mr. Wesley Kearns. He's my staff attorney. And then the gentleman who just brought you out is Sergeant Tim Ingram. So, and then I have another litigation manager upstairs, Edward Chamberlain, and you'll meet him at some point in time if you haven't met him already when you were here before. So, as I mentioned earlier, they're here to assist me and will be happy to help you in any way you can. Your principal point of contact, should you be running late or anything should happen to you or you need to kind of reach us before the time period. I understand one of you had a car issue this morning, so that's you all still have my cards? Okay, and if you don't, I got plenty more. We'll give you some before you leave today. If you're going to be running late or anything, please contact Ms. Umana and let her know so that I can kind of keep track of you and I can let the parties know where you are. But it is very important that you all get here on time. We were supposed to start at 9 o'clock this morning. It's now almost 10:30. So I can't do anything until all 18 of you are here. So please mind your time. Only you know how long it takes you to get from wherever you live in our great county downtown Fulton County, to the courthouse and all the machinations that you have to go through. So leave early. You can always come a little bit earlier and be comfortable and be seated in your headquarters at your deliberation room, okay? All right, but at any point in time during recesses, you can approach my staff, or as I mentioned earlier, any of the people from our sheriff's department who are in the gray and black uniforms, you're authorized to talk with them. Before we get into preliminary instructions, ladies and gentlemen, I have some administrative matters to discuss with you. I've already introduced my staff, and I encourage you to approach them if you have questions. Remember, the sheriff's deputies have shown you how to get to the jury room, how you arrive here every day. Okay, so you're never to come into the front door of the courtroom. You always go in to the rear and go directly into your headquarters at your deliberation room. And from this point on, you're not going to enter the courtroom unless one of the deputies brings you out from the jury room. After breaks at the beginning of the day, when you arrive, you'll go straight to the jury room, and our deputies, as I mentioned earlier when you were here a little bit earlier, gave you the nickel tour of the courthouse. So all of you know how to get from the front entrance up here to your headquarters. Is that right? Okay. We talked a little bit about meals and how you can, there's a cafeteria that's directly behind you. We talked a little bit about that. Since you were here, you like the space back there?
Yes.
It no longer looks like a dump. We painted it, got you some fresh tables, chairs, and a couple of refrigerators, a microwave, a coffee pot, and we'll make sure that we go ahead and make sure that is cleaned and maintained for your use. I want you to be very comfortable while you're in there. But as I mentioned to you earlier, it might be better just to bring your lunch or bring your comfort items, but we'll make sure that you have some place to store them and otherwise can warm up your lunch if you feel necessary. All right, I would ask that you wear your juror stickers when you're here in the courthouse, and all of you have juror stickers, wonderful. If you don't, when you go back in there, put one on, and remember at the end of the day, take one, put it in your wallet, your purse, your briefcase, whatever you may have, and put it on when you come back in the courtroom and in the courthouse. This is so the lawyers and the witnesses can identify you as a juror. From this point on, the lawyers, the parties, the witnesses, or anyone else associated with this case, except for my staff or our sheriff's deputies, is prohibited from having any contact with you whatsoever. If you happen to encounter any one of them on the street or in the elevator, please do not attempt to communicate with them in any way and do not be offended, as I mentioned to you earlier, if they ignore you, okay? They're just adhering to their responsibilities and roles as officers of this court to not have any direct or incidental contact with you. So please don't be offended. If you should some reason have contact with one of the lawyers, or if you inadvertently overhear something about this case, please notify one of my deputies or my staff immediately. Now, this also, ladies and gentlemen, pertains to third parties or anybody else that may try and talk with you. If anybody else, other than the folks I told you about, the lawyers, attempts to talk with you in any way, emails you, texts you, tries to communicate with you when you're going to and from, we need to know about it immediately, okay? So please tell me if that should happen. We generally hold court from 9 a.m. to about 6 p.m. or thereabouts. We'll take some short comfort breaks as needed throughout the day and a longer break for lunch. And for the sake of your fellow jurors and the parties, as I mentioned earlier, please make every effort to be on time, as we cannot begin or continue the case until all of 18 of you are present. If something unexpected happens and you absolutely cannot help being late, please call my office and contact Ms. Umana, and she'll let me know and let us know accordingly. All right, ladies and gentlemen, now I'm going to cover some basic principles of criminal law. I'm going to explain my role, your role, and the lawyer's roles. And then finally, I'm going to tell you how the trial will proceed. Since many of you haven't served on a jury before, so this should help you in understanding how a trial proceeds and what is expected of you during the trial. Now, you've been selected and sworn to try the following: the criminal case of the state of Georgia versus Marquavius Huey. The Fulton County Grand Jury has indicted the defendant Marquavius Huey with the following offenses, which I'll read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, armed robbery, aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, possession of a firearm during the commission of a felony, armed robbery, aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, hijacking a motor vehicle in the first degree, possession of a firearm during the commission of a felony, possession of a firearm during the commission of a felony, participation in criminal street gang activity, participation in criminal street gang activity, participation in criminal street gang activity, possession of a weapon by an incarcerated individual, possession of a telecommunication device by an incarcerated individual, and participation in criminal street gang activity. The criminal case of the state of Georgia versus DeMonte Kendrick. The Fulton County Grand Jury has indicted the defendant, DeMonte Kendrick, with the following crimes, which I'll read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm in the commission of a felony, possession of a machine gun, and possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Quamarius Nichols. The Fulton County Grand Jury has indicted the defendant, Quamarius Nichols, for the following crimes, which I'll read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Rodeus Ryan. The Fulton County Grand Jury has indicted the defendant, Rodeus Ryan, for the following crime, which I will read to you now: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act. The criminal case of the state of Georgia versus Shannon Stillwell. The Fulton County Grand Jury has indicted the defendant, Shannon Stillwell, for the following crimes, which I will now read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, murder, participation in criminal street gang activity, participation in criminal street gang activity, possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm, possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon previously convicted of felony involving the use or possession of a firearm. The criminal case of the state of Georgia versus Jeffrey Williams. The Fulton County Grand Jury has indicted the defendant, Jeffrey Williams, for the following crimes, which I will now read to you: conspiracy to violate the Racketeering Influence and Corrupt Organizations Act, participation in criminal street gang activity, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, violation of the Georgia Controlled Substances Act, possession of a firearm during the commission of a felony, and possession of a machine gun. Each of the defendants have pled not guilty to this indictment, and each of them deny every charge in it. This indictment and the defendants' pleas of not guilty present the issue that you've been selected and sworn to decide. The indictment is a way the defendants are charged with committing crimes that violate the laws of Georgia. The charges in the indictment and the pleas of not guilty are not evidence of guilt, and you may not conclude the defendants are guilty based on the charges or the not guilty pleas. Each of the defendants is presumed to be innocent until he is individually proven guilty. The defendants begin the trial with a presumption of innocence in their favor, and this presumption stays with them until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendants are guilty of the crimes charged. You may not convict any one of the defendants of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendants have no burden at all, and the burden never shifts to any one of the defendants to prove his innocence. However, the state is not required to prove the guilt of the defendants beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which you can give a reason based on a consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. After considering all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendants not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendants. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendants not guilty. My role is to determine the law that applies to this case. Then I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of those instructions now. I will give you more detailed instructions at the end of the trial. The jury has a very important role. You must decide the facts of the case from the evidence presented and then apply the law that I give you to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimonial or exhibits. Testimony is what you'll hear from people who take the witness stand right here and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, and other physical items that are admitted during trial. The object of this trial is to discover the truth. During the trial, I will admit evidence according to the rules of evidence. Those rules are designed to aid in discovering the truth by making sure that you consider only the best and highest evidence. The lawyers are advocates for their clients, and they have the duty to represent their clients to the best of their ability. They must follow the rules of law, trial procedure, and evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. Remember, what the lawyers say in making or responding to objections is not evidence. I will admit or exclude evidence according to the rules. If the lawyers make an objection and I overrule it, that means the evidence is admitted and you may consider it. On the other hand, if I sustain an objection, this means the evidence is excluded from the trial and you may not consider it. You should consider only that testimony and only those exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and nothing I say during the trial are evidence. My decisions and remarks do not mean that I favor or lean to one side or another in this case. I am only interested in seeing that this case is fairly tried based upon the laws and Constitution of the state of Georgia and the Constitution of the United States. Sometimes I may have to deal with the lawyer's motions or objections without you being here in the courtroom, and if so, I'll excuse you from the jury room. So what I'll say, ladies and gentlemen, is, ladies and gentlemen, there's a matter we need to take up. If you retire to your headquarters or jury deliberation room, and I'll wait further instruction. That's my most artful way of telling you we need to take up something outside your presence and hearing, okay? I'll try and limit those interruptions, and I ask that you be patient when they do happen. I can't tell you when those will happen, but sometimes they do. So please I'll ask for your patience in advance on that particular matter. So the trial will proceed as follows. First, the attorneys may give what's called opening statements. No attorney is required to make an opening statement. Opening statements are not evidence. They're simply an introduction to the evidence, a preview, or an outline of the expected evidence. The state goes first because they have the burden of proof. Second, the evidence will be presented. Third, the lawyers may give closing arguments or summations. They may discuss the law that applies to this case and how you should consider the law in light of the evidence. They may also point out evidence that they believe supports their position. What the lawyers say in closing arguments is not evidence. The goal of a closing argument is to persuade you to decide the case in their favor. Fourth, then I will explain to you the specific law that applies to this case. This is referred to as charging the jury. I will then ask you to go to the jury room, your headquarters, to deliberate and to reach your verdict. It is important that you pay close attention during this trial. If at any time you cannot hear or see any evidence, or you're suffering from any discomfort that distracts you, please inform me or one of my deputies or my team, and we'll do whatever is needed to make sure you can hear and see the evidence and give it your undivided attention. If you need a break at any point in time, please raise your hand or alert one of our deputies. The jurors are not allowed to question witnesses. However, if you have a question you believe is important for your determination of facts, please write down your question, give it to one of the deputies, and I will determine whether or not it should be asked. If you have a question while the evidence is being presented, please keep in mind that you do not yet heard all of the evidence, and your question may be answered by the time the rest of the evidence has been presented. You should only consider evidence with you should consider the evidence with an open mind, and you should not reach any final conclusions until the trial is over. Do not jump to conclusions before all the evidence is presented. To maintain the integrity of the jury system, I'm going to remind you again, remember my ad nauseum admonitions there? Okay, y'all shaking your heads like, okay, we're going to go through those one more time. I'm going to remind you that you must decide this case only based on the evidence admitted during the trial and the law I will explain to you. You may not conduct any research on your own about this case or about any people or places mentioned during the trial. You may not visit any places mentioned in the evidence. You may not refer to any books or documents that were not admitted during the trial. You may not use any dictionaries or other reference materials. You may not use Google or any other search engines or any other resource matters, the internet, websites, or blogs. You may not use any other electronic media to get information about this case. You should not use any of the sources to get any information about the legal terms or about the law. And finally, you may not listen to any accounts of this trial that may appear in the news media, whether it's online, in print, on the radio, on your cell phones, or any other smart devices that you may have, or any other mediums. Remember, you are the ones that have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. For that reason, as I mentioned earlier, part of my admonitions, you may not discuss this case with anyone, including your family and friends, or let anyone discuss this case with you or around you or in your presence. This includes discussing or sharing information by email, text, blogging, or other form of social media until actual deliberations begin. That is, until after you've heard all the evidence, the lawyer's closing arguments, the law that applies to this case. You must not discuss the case even amongst yourselves in the jury room during breaks or elsewhere. Remember I told you, would it be a violation for you to sit back in your headquarters jury deliberation room after we take the first witness? Say, hey, what do you think? Is that a violation? Yes. Come on now. We all got to kind of shake our heads. Yes. Would it be a violation for you to be, as you're walking lunch, to recap and discuss the case?
Yes.
What about you in the bathroom?
Yes.
That's creepy. Remember I told you about that before? Okay, all right. So we're not going to do that, all right? But what about going to the juror shuttle? Yeah, that'd be a violation as well, okay? What about if you're walking on Wednesdays and Tuesdays? All right, okay, and how did I tell you you're probably going to get caught if you violate my admonitions? You're going to tell on yourself, that's right. Or somebody's going to tell me that you've been on some particular site or some particular issue. You ought to be able to learn that. Okay, I'm proud of you. All right. But it's really important, ladies and gentlemen, because remember I told you, fair trial, just trial, lawful trial. So all of these things are really important in terms of the admonitions and how serious we are about you not being only hearing what's in this courtroom and only the cases presented to you. All right? So you've been given pencils and writing utensils and pads for your note-taking and use during this trial. So what I want you to do at this point in time is take and open your pad to the very first page. For those of you that have them, okay? For the rest of you, I'm going to get you a pad, all right? Okay, does everybody have a pad? No. Okay. Okay. All right. Who else doesn't have a pad? Do we have enough, or we'll get you one during the break. What I need you to do with all of you that have pads, go ahead and write your name on the very first page. Okay, that's your pad, okay? So whenever you come back in, after breaks and everything else, if you're going to your headquarters, just leave your pad inside the basket, okay? We're not going to take a look at it, and nobody's going to bother with it. Who else needs a pad? Okay, everybody got a writing utensil? Pen or pen or pencil? Okay, for those of you go ahead and who just got pads, go ahead and write your name on the very first page, inside cover. Just go ahead and write your name on it. And believe me, we have more pads, so if you get, by the time the trial ends, if you need another pad, we'll give you another one, okay? So, but leave them in your headquarters when you have breaks and go outside and for the end of the day. Just put them in there, take another juror sticker out, and that'll be kind of your way to kind of just trade and make sure, don't take them home with you. Then the next morning, you can find your pad and you can kind of just be prepared to take notes, okay? So I'm going to tell you that again. Just leave your pads as you have breaks and everything else in your headquarters. And at the end of the day, like I said before, we will secure your notes. That'll probably be Miss Umano's job, and we'll just leave them in the basket, and we put the basket in your location, and then we bring the basket back down, so you all, when you come back tomorrow morning, or whatever morning you come back, you'll have your notepad, all right? Now, but please keep in mind, all right, you may take notes if you wish. If you do take notes, please do not let your note-taking distract you from paying full attention to all the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberating at the end of the case, and I tell you how you're to begin your deliberative process. Notes are not evidence, they're only memory aids. They are not more important than your own impression or memory of what the evidence may have been. You may consider another juror's notes to refresh your memory, You should only rely on your own memory of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent memory. You must leave your notes in the jury room except when you are in the courtroom. They will be collected by the court and destroyed at the end after you finish your deliberations. Ladies and gentlemen, you will not get a transcript of any witness testimony, so please remember what they said on the witness stand in a way that works best for you, okay? I'm gonna tell you a couple other administrative, or as I call, administeria. Ladies and gentlemen, I've tried a lot of jury cases, so some of the things I'm gonna say to you are the result of debriefing a lot of our citizens. One of the questions I get on a routine basis is, Judge, what are you doing up here on the bench? All right? So I'm going to demystify that, and I'm going to tell you right now. So there won't be any question about what I'm doing, okay? All right. So as I told you earlier, I'm responsible for just about everything that goes on in this courtroom. So on the bench here, I do have a phone, and I can make certain phone calls I need to. These devices here, ladies and gentlemen, you're going to see us use them from time to time. They are audio devices that each pair of litigants has on their table to allow them to hear bench conferences, because I may have to take up things out that I told you outside your presence and hearing, but we may not want to put you out of the courtroom, so we may come up here, I cut my microphone off, and everybody using these devices is able to hear the bench conference that I'm having. Will you be able to hear a bench conference? No. That's not for you to hear. So, but these devices allow us to do that. So if you see people putting on these particular devices to talk, such as this, you'll know that that's what's going on, okay? All right. To my left, I do have a computer. I have a couple of different programs that are open that help me do legal research and other things to keep track of what's going on during the trial. And otherwise, I'm taking notes. So if you see me typing, don't assume I'm booking my next vacation. I could probably be doing that, but I'm not. I do take notes, and I do pay attention to what's going on. I of course, I'm very interested in your comfortability, and I monitor everything that's going on here in the courtroom. So that's what I'm doing up here on the bench, all right? One other thing that you might hear behind me is this bell that starts jingling, all right? And if you hear a jingling sound like a bell, please don't think that I'm doing anything creepy up here, all right? I have a service dog behind me. His name is Jack. I think some of you may have seen him already. He lives the best life ever. He's pampered. He's really, and he is a Labrador Retriever. He's about almost 2.5, 3 years old at this point in time. So, but if you hear that bell, that's him moving around, all right? He doesn't bark. He rarely gets interested in what's going on, so he might come up here and look, but that's about it, all right? Don't bring him any food either, okay? All right? He is spoiled rotten. So please don't try and throw any food back here behind me or anything like that. He doesn't need anything else, okay? But if you hear that bell, hear that sound, that's what's going on behind me, and he'll get up when we have breaks and whatever else. So, but that's if you hear the bell, that's Jack. All right. Ladies and gentlemen, I think we're ready for the lawyers to begin their opening statements, and what we'll do is we'll probably go till probably about 12:15 or so, and then whatever we don't get done, we'll just continue on at that point in time when you all come back from lunch, okay? So at this point in time, counsels, I'm going to invoke the rule of sequestration as to both sides. So anybody who's going to give testimony in this case, if you please absent yourself from the courtroom, please don't discuss your testimony to anybody except the attorneys in this case. So at this point in time, does the state wish to make an opening statement?
The statement, Your Honor.
All right, go right ahead, madam.
Your Honor, I would ask the court regarding certain members that we have spoken with in court about in terms of witnesses, whether they are allowed to remain within the courtroom.
I believe the matter that we discussed, we won't be able to take up till Tuesday. So that person should probably be excluded. That person, if they're going to. But other than that, I think we've covered everybody else. Unless there's an exemption, do you have an exemption to the sequestration?
Your Honor, the family members of the victims themselves were the only ones that I was concerned about.
There's no issue about sequestration as it applies to them.
Thank you.
All right.
Excuse me, Judge. I have several objections to the court's opening charge. Would you either reserve those or...
I'll reserve those.
Thank you.
Okay? All right.
Your Honor, can I just make sure that all the witnesses are excused? Because I think there's been mixed messages sent by the attorneys, not by the court.
Okay, all right. Okay.
Your Honor, may I please approach the bench?
Say again?
May I please approach with the state?
Yes, Ms. D. Williams. For those of you that wish to listen in, you can go ahead and do so. It should be good. Yes, ma'am. Yeah, they can hear you.
Can't hear, Judge.
Say anything yet. You good?
Can't hear.
We could have taken this up like 45 minutes, an hour ago.
I can't hear you.
Yeah. What's that? What's that? I'm sorry.
I can't hear you.
Okay, if we can, I'm going to switch, okay? Yeah. Okay? All right. I'll exclude that in the motion for the time. Okay, all right.
Can't hear you.
You only 3 minutes to do it. Okay. All right. All right. No, they should have just, everybody gets at least one. Who? No. No, they're not, they're not on camera, should they? Who? Then cut the camera off. Tell Beeler to cut that camera off.
Okay.
Which camera is it?
Witness. Witness.
Your Honor, when the court has a moment, can we approach again with Ms. D. Williams?
You need 3 minutes, you said?
Your Honor, we just need to reapproach again, Your Honor, briefly, given that we just learned about this.
I'm going to exclude it for the time being, okay? Let's just move on. I'll take it up at another time. We're not going to take it up right now.
All right, thank you, Your Honor.
Your Honor, given that I have provided certain things, I just want to make sure that I comply with the court.
Yeah, we could have taken that thing up an hour earlier, but I'll take that issue up later.
Okay.
Let me know when you're ready, ma'am.
We're ready.
Okay, all right. All right, if you wish to make an opening statement at this point in time, please go ahead. All right.
I'm going to now share my screen with court for me.
Yes, ma'am, go right ahead.
Thank you. Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today, during the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were right out Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. they adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Believeland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotics sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting, and under Parker versus the state at 277,
Why don't we take that up and
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence. They're presumed innocent, and it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time. Okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read or spoke to you earlier goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not.
What's your objection, Mr. Harvey?
That it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew, and they knew, that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they called him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You'll hear experts come in here and tell you more about how the Inglewood family Bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies. 2015. Gunned down. Openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift Young's Limelight had with other people in the community. So what are they accused of and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state will be proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement, to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if 2 people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and went and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they're agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-arm guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Flamarius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
You have an objection?
Yes, sir.
Basis?
The motion.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters at your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right? Remember the court's admonitions, ladies and gentlemen. All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention, 1? And 2, how do we just violate court orders? So, yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it as next court exhibit in order of the state's presentation anyway, so. All right, so that'll be court one for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I was never said this ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
Brought up to this honorable court, outside the presence of everybody. We're an opening statement. I am lied to. I am saying that. I am lied to. I don't know if anyone else got that exhibit. I did not get that exhibit. And I see everyone's head shaking no. And now, it goes against the court's order. We are bound, duty bound, to follow this honorable court's order.
I'm going to join in the objection on behalf of Mr. Steele.
Let me see the...
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. That we were not, I would take it as it came in this case, and if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
and Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have the...
all right.
The slide.
Well, now
I have it now. I'm
court
about to share
court
this.
one for purposes of the motion for mistrial. All right. Okay, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what was it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a re-encourage the court for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
you made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as court one for the purpose of your motion, and it will go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacted through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us. So
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right, Ms. Lowe.
Yeah. Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation. And just like this, so I assume that what you told our jurors is what you expect the evidence to show? Yes?
Yes,
All right,
definitely.
so I'm going to overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in open you haven't shown to defense counsel? He's telling us. Well, I said that. I told you to do that a week ago.
Your Honor,
because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Ms. D. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So, have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, Ingram, can you find out if our jurors are ready?
Are they with them?
Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, can we have a few? Your Honor, Jay Apt on behalf of Mr. Kendrick. Can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
Max Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell.
We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial, and if Your Honor...
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial?
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes, all right?
Your Honor, what I'm going to do before sitting is I'm going to actually do a search for the first four letters of Mr. Steele's name to make sure that I didn't need anything else in there. So before I do that, I'm going to send that. I'll make that search.
Concluded our sharing exercise. I told you all to go ahead and talk with each other through when we broke.
I did share it, Your Honor. If I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hilton shared with me what was said on the bench. But as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, including things, but, Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint, I can show to the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are things that the courts have said jurors and the courts should look to and determine whether something is done in furtherance of a gang. And so I would ask the court, I did take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. Adams. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as...
Say again, madam? I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to...
Yes, ma'am, I would probably agree with you, but did I ever rule on that issue?
You said that you would do it later as it came
Okay,
up.
well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks. And my client has nothing to do with that.
That was another area I'm going to correct that.
But I didn't get that
Ms.
slide
Love says
presentation
Ms.
earlier.
Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I sent to them if they can. Actually, I sent them to them. So there are some. I have only about.
Your Honor, they're a dump over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Abbs.
So all of these slides that involve Christian Ebinger, I sent to them. And other than the slides involving Christian Ebinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that I'm not certain if Mr. App thinks that we only served 4. Maybe, I don't know if he had trouble opening it up, but we served, I think, all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I will share it if I did not, with the court as well. But these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted, and then I have pictures of Christian Ebinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. App, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument. But if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative. She could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of our opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today. Whether they're evidence or whether they're text is part of her opening.
All right, Mr. Matthews?
Yes, Your Honor. Good morning to the Honorable Court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020 in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation. That's number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquavius Hugh. And then you go to slide 16. Slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020, but in the indictment, that particular overt act is November 16, 2020. So that's the third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask that the state correct that, remove it, or correct it.
All right. Anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet, and I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also number, I'm looking at it now, 48, 49, 53, 54, and 55. That's your prerogative. That's within your zone. That's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides you talking about, Mr. Steele, again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so it's 48, 49, but then skipping to 53, 54, and 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please, ma'am.
Thank you. And you said, Mr. Steele, you said 45?
Just share the presentation, please.
Yes, Your Honor. Okay, so Your Honor, I'm showing on the screen slide 48, which is the last thing that the court.
Take notes.
Yes, Your Honor.
All right.
And
49.
that was directly from what the court just said.
All right. 50.
50.
It's not 50, sir, 53.
53. Let's get down to 53. And 53 is what I expect the evidence is going to show. So I'm going to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid. Some of them are embarrassed. Some of them are intimidated. Some of them don't remember. Some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are embarrassed. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor. I went over to the state's table. Carson Matthews and Beth Mistrial went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, State?
Not yet, but in a moment.
All right, here's what I'm going to do. Folks, this is exactly why I told you I wanted you to, and let me go ahead and just say this. Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. They need to get, and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So,
Your Honor, as far as any typographical errors,
I'm not worried about that. I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Short have made are errors, and Ms. D. Williams need to be corrected. Okay?
yes, Your Honor, I will, of course, report.
And but everyone else needs to see it so they can be comfortable and make sure that you've represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point. I'm going to tell them that. And I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Desmond, Sergeant Ingram, can we go ahead and call for our jurors, please?
Also number 6-2.
You can go ahead and take up that during the recess. Okay?
Yes, sir. Thank you.
All right. Yes. Okay, ladies and gentlemen, please be seated. All right, members of the jury, we apologize profusely for the delay, but I got some good news. I'm going to send you lunch. How about that? The bad news is I'm not paying for it. So hopefully you all brought something or have made suitable plans consistent with the court's earlier suggestions to you. So what I'll do is at this point in time it's about 12:20, almost 12:25. I'm going to recess you until 1:45 to allow you to take comfort and take a big long stretch and get yourself something to eat. I would advise you from doing this a while. Don't eat too much carbohydrate-laden food because you will fall asleep. And then I'll be looking at you and have to embarrass you. I don't want to do that. So I just ask you to take that nugget of consideration from somebody who's been doing this a while, all right? But remember my admonitions I told you. Remember when you go out, if you should decide to go out to eat lunch, remember you've got a time deadline you need to get back for, because we're going to try and call everybody out promptly around 1:45 or thereabouts, and go ahead and get started. Leave your notepads in your basket if you decide to go out there, and remember all the admonitions that I've given you thus far. They apply to you and continue to apply to you. All right, so unless you have any other inquiry of me, ladies and gentlemen, I'm going to bid you a good lunch, and we'll see you back at 1:45, okay? All right, all rise for a jury. About time. Please be seated. Our jury has left us. All right, so ladies and gentlemen, consistent with my earlier directions, go ahead and take a look at that, make those corrections, and I'll see everybody back for 1:45, and we'll go ahead and continue with opening statements at that point in time, okay? All right, we're in recess. we have some conversations about the PowerPoints?
Your Honor, the court did share, the state did share its PowerPoint with the defense. We went through and made any corrections to typographical changes or indeed to the PowerPoint itself. They are actually able to access the state's PowerPoint in real time, so they can see any change or anything that we made. We actually took out most of the photographs that we initially included, particularly most of Christian Evinger. So I have not heard from anyone on the defense team that there's any other objections. We added back in Rodelius Ryan's party opponent admission on the date of the murder of Jamari Holmes. And we would like to, but have not, add the third homicide victim's photograph in. And that was it. So I have not heard anything from anyone regarding any of the changes.
Okay. Do I have any further objection? Are there any further objections to the state's PowerPoint that you all, or changes that you all individually have objections as to going forward?
I would propose, sorry.
Go ahead, Mr. Steele. Your Honor, I understand the court's ruling, previous ruling. Just renew my objection that I think because the state didn't turn these over, they should be excluded.
Mr. Steele?
Yes, Your Honor, I was unaware that there were changes. I apologize. No one told me that. I didn't get an email to that or text.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
That's what I've been doing. I've been waiting. I've been right here. The hallway and in that other room gate. So I understand that the state updated something and not realize that that's what they were doing.
Your Honor, we did indicate that we would be making those corrections.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water. You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. These jurors are waiting back there. We are dallying out here. So, you didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So, any further objections?
Yes, Your Honor, I didn't know that they were changing.
Yes, Ms. D. Williams.
And on slide 10 and 13, they misquoted the Instagram post.
Again, they misquoted it?
Yes, they did. It says, I bet YSL make the news tonight. That's not what the Instagram post says.
Your Honor, we actually copied the Instagram post into slides 10 and 13.
And it does not say tonight.
I'm sorry, okay. I will take out the word tonight. He's right.
Anything further? Mr. Shard, did you rise to?
Well, I'm just seeking I, on behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show an updated version?
In fact, it does. It has on every other person's computer who has this PowerPoint, and at the appropriate time we would. Mr. Sharp shared his PowerPoint. We were able to see it, and the state has objections to the argument slide in Mr. Sharp's PowerPoint that we would like to stress before in front of the jury.
Could you repeat that, Ms. Love, again?
Yes, Judge.
Mr. Harvey can't hear back there.
So the state shared its PowerPoint with all parties, including other members of the state's team, and the other members of the state's team that have looked at the PowerPoint, they were able to see in real time the changes that are being made, as are anyone with the link that I shared with the defense earlier. Additionally, Mr. Sharp over the lunch break shared for the first time his PowerPoint and has included slides to which the state objects and has responded and told the court and Mr. Sharp that we object to. But I just wanted to make the court aware before we were in front of a jury again, as this, I think, is the appropriate time to do so. But the changes that the state made were available and published to everyone on counsel for the defense team.
All right.
Okay. I think the confusion, Your Honor, I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with a new version of the PowerPoint.
That's not what I told you all to do. I was pretty clear. I said, y'all over lunch, just take a look at the state's PowerPoint. Make sure you have no further objections. I didn't tell you to email it to you. I just told you to look at it. I don't care how you did it, but that would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. We were waiting, we had voiced some concerns already, and we were waiting on the new version. And I'm just explaining, Your Honor. I don't think anyone was aware that it was being edited on that old link. I think people were waiting on a new version of the PowerPoint.
Okay. Here's what I'm going to do. I'm excluding the PowerPoints. Y'all are just going to have to make this thing up the whole way. Yeah, just make an opening statement. No PowerPoints. Let's bring our jury in. No PowerPoints, because you all did not do, hold on, sorry, Ingram. You didn't do what I told you to do, and that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done. And my orders to you are not aspirational. They're given for a reason. And when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints, okay?
If I could address the court, Mr. Matthews from Mr. Hugh. In terms of what we have done here on our team, we have provided our opening statement to the state of Georgia, as well as to every other person on the defense side. We have received from the state of Georgia an updated, came to my email from the state of Georgia with the changes as it relates to Mr. Hugh. I have it. I will be hamstrung, Your Honor, if I am not able to use my opening statement because I prepared my case with my opening statement. I have not committed every single slide to memory, Judge. I'm depending on my opening statement to present to the court, to the jury, Judge. So I'm asking the court to reconsider its position as it relates to Mr. Hugh. Respectfully.
All right. Mr. Steele?
I sent our entire PowerPoint to the state of Georgia last Tuesday.
Which the court has already. I do acknowledge that.
Now I did everything the court demanded.
All right.
So I'd like to use mine.
Okay, all right.
And Your Honor, to be clear, on behalf of Mr. Stillwell, I sent over all the...
When did you send it?
On Friday, I sent all the photos of the exhibits that I plan to use or the demonstratives I plan to use, save for one which I did not have physical custody of, which is a Fulton County jail uniform, which I took a picture of. And I have it with me right now. But I did not have that on Friday when I sent that over. I did not have custody of that object. Regarding the PowerPoints, when the state finally handed over their PowerPoint and said that they didn't realize they were supposed to hand over the entire PowerPoint, but these exhibits, which they didn't do that either, by the way. I did. I sent them out of an abundance of caution my entire PowerPoint. So.
And Your Honor, I don't object to, generally speaking, the PowerPoints that have been shown. What the state did do was exactly as the court directed during the lunch break, as Mr. Matthews was able to see, we provided to each member of the defense team every change that we made. And respectfully, Your Honor, we would also request that the court allow the state to continue in the path that it has gone. We have complied with the court's directive.
No, you didn't actually. The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours on doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we were going to end up dealing with a lot of objections. And I don't mind dealing with the objections, but I got to have time to do so. So that's why I told you I had to started having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could. That, obviously, very few people adhered to the court's instructions, and we find my words to you a self-fulfilling prophecy, meaning that we are still dealing with this particular issue, and our jurors are waiting on us. So,
Your Honor, we have, as well, as I stated, we provided the photographs we intended to use.
When did you provide them?
Friday, before 5, Your Honor. The language that is in the PowerPoint are the words, our opening things. They all have that. Everyone has that. I don't believe that there is a general objection to that. Every objected to portion of the PowerPoint that the state has, Your Honor, has been modified to address those objections. And we just ask the court to allow the parties to proceed as we have been proceeding with respect to presentment of opening statements. Additionally, Your Honor, I am not objecting on the basis of anyone having given the state the PowerPoints today. I'm not objecting as it relates to when anyone gave us the PowerPoints. I only objected to these photographs that were provided to us just a few moments ago on the basis of that they were argumentative. And I want to bring that to the court's attention. If the court decides that they stay in, even though they're argumentative, the state has, we can get past that quite easily. We would just ask that the court allow the parties to proceed as we have.
Are you referring to I'm in possession of 2 emails with photographs, while I mark it as the next court exhibit in order. One of them is, it has the subject of state objection arguments contained in Shannon Stillwell slides below, and I have a couple of, it has like 3 slides.
Yes.
I'm going to mark that as the next court exhibit in order.
Yes.
Mr. Sharp, why don't you believe this is objectionable? It would seem to me it's got pictures of a couple of folks here in our facility, and a picture that's probably more prejudicial than probative, and it has somebody that purports to be an inmate. So why wouldn't that be?
I don't think, Your Honor.
Yes.
I don't believe, I'm not seeing the email. I see an email saying the state objects to the use of these photographs during opening.
It's got your 4 slides, state's key witnesses, Nicholas Robinson, and then Nicholas Robin, a.k.a. Spencer Wright. Those are 3 that I'm looking at.
It's not showing that in my email. I'm seeing 2 pictures of jail.
I got that one too, which I'll mark as the next court exhibit in order, and that's the 2 pictures that you referred to. And it has the state, subject matter is the state objects to the use of these photographs during opening.
Could I see what we're talking about? Because I don't have it on my email.
Sure.
I'm not seeing it.
Christina, can you mark these in the next court exhibits and then show them to Mr. Sharp? Counselors, you can approach and take a look at it.
And Your Honor, the court will advise.
Hang tight. Which one did you mark it as, so we can?
It's marked Exhibit 2.
Court's 2? Or
yes.
Next court's exhibit in order, okay. All right.
And I wasn't on that email, and that's fine. I just wanted you to, that's why I hadn't received it. So this case is going to involve...
objectionable.
Well, I'm allowed to preview the evidence that I believe that will come out. I not only believe, but I know that several of the witnesses in the case, which I'm going to discuss in opening, became involved in this case once they were in the Fulton County Jail. They were jail inmates. Okay? Now, I'm allowed to preview the case in that way. To the extent, if the state has a particular argument or objection to one of the photos, then we can talk about that. But okay,
Court does.
Well, I can alter my.
I mean.
So what is it you want me to alter, Your Honor, to avoid
the picture? And if the state doesn't have any objection to the, you saying anything about any other witnesses in custody, then that's certainly within their purview.
Well, the case law, as I understand it, allows us to preview the case and let the jurors know in advance that witnesses were in custody at the time they made statements. That is completely appropriate as under the law, as I understand it. Now, if there's a problem with the pictures, as I said, Your Honor, I will remedy that. That's not a big deal.
I would ask that you take the pictures out. Okay.
That's fine.
What about the argument in the pictures seem to be, and that would solve that issue. So what about the other issue about the slides?
Well, they also said this Nicholas Robinson one. I'm not sure what their objection is. I will be letting the jury know, which will come out in evidence, that a man who claimed to be named Nicholas Robinson was arrested on October 19th, 2015. He's an important witness in this case. They will know, the evidence will show that he was interviewed by Detective Thorpe, and he gave his vantage point of where he was, and he told a story which involved the guilt of 5 people that are listed on this slide. And that evidence will come out at trial, and I don't see anything objectionable about this at all.
All right, Ms. Love.
Judge, I don't object to Mr. Sharp telling the jury the words that he has shared with the court. What I object to is the imagery that is depicted in the...
You mean the person that's in a uniform as well as the purported condition of the jail in that lower one?
Well, correct. That's a separate slide. That's a separate slide. These are 2 separate slides. I just want to make clear. These are 2 separate slides. So I'm saying that I'll take out the pictures.
And also the giving of the false information. So the problem that I have, the only problems that I have with the language in the other slide is that part of that information is improper impeachment that Mr. Sharp would not be able to introduce at trial.
Except that...
And I don't have any problem with Mr. Sharp telling the jury that the evidence will show something about Nicholas Robinson, but he has listed all of the arrests for Mr. Wright, Mr. Spencer Wright.
Who is Nicholas Robinson, Your Honor, just so the record's clear? Your Honor, as Your Honor knows, we're allowed to impeach with prior convictions.
You gotta be called first, right?
But we are also able to impeach with bias. And the fact that this gentleman was arrested, Your Honor, that's the central crux of this case, and it's something that the jurors need to be made alert and to look out for as this case is presented. The bottom line is Mr. Wright, who identified himself as Mr. Robinson, was arrested on felony charges and probation violations on 10/19/15. And then he reached out to APD and said he wanted to give information, and then he met with Detective Thorpe. Nothing I'm saying is incorrect. It's all accurate. It all would go to his bias and motive and reasons for coming forward. And
All right, so you're saying this is what he was arrested on the 15th?
Right.
On 10/19/15?
Correct.
Okay, all right. Okay.
And quite honestly, off the top of my head, I don't know how those cases were resolved, but they were biased at the time that he made those
Are
statements.
you saying that because the evidence will show that he then gave information against your client?
Yes.
Or involving your client?
Yes.
And Judge, I don't have a problem with him saying that Mr. Wright was in jail. I don't have a problem with him saying he had open charges. It is the listing of the specific ones that we objected to.
I don't know why that's
Because they are
objectionable.
not convictions, and that is not the proper method.
Yeah,
to
I would
show
agree with that. So you can talk about, unless you get them in a proper format, yes, you can talk about if you have criminal charges, that would be appropriate. What happened as a result of that, but I think the laundry listing of that, because you said you don't know what happened to him, so.
But the reason I'm saying that is because I think it's irrelevant, because this is really about bias.
It's not proper, though. It's not proper format. Bias is fine. You can talk about the...
But he had the bias because he was facing these... Certainly, if someone's arrested for murder...
You just can't mention the individual charges themselves unless they're in the proper format.
I
okay?
understand. But my only point would be, Your Honor, certainly if someone was charged for jaywalking, arrested for jaywalking, and someone else was arrested for murder, the bias, the level of bias would be different. So,
okay, but what does that have to do with them not being in proper format, though?
Because the jury is allowed to understand specifically what bias the person has. Not that they're just in jail, but what they are facing.
If you can get it in the proper format, then it can be, and you can tell them about that. Do you know what happened in these particular charges?
Well,
is Nicholas Robinson going to testify?
At the time that
answer my question. Is Nicholas Robinson going to testify?
If the state doesn't call him, I will.
Okay, well then, at that point, then it might be appropriate for you to get into that specifics. But unless you're going to package that up, and certainly that's not, you can decide that. You don't have any responsibility to present anything on behalf of your client. But in order for you to delve into it, it has to be in a proper format. I would agree with the state with that. I was sustain that objection. But you can talk about arrests, you can talk about pending charges, you can talk about that, you'll present evidence sufficient to show that he's got an axe to grind, he's got bias.
So you're, just for clarification, because I want to get this right, we're saying your instruction is that I can say that he was arrested and he had pending charges, but I just can't say what those charges are.
Until and unless they become you get them in the proper format, or you have a witness you can lay a foundation for those. Okay?
Okay, and the third thing, Your Honor, is I have a Fulton County jumpsuit. This is the same uniform, not actually the same one, but is the same make and model that a number of the state's witnesses were wearing when they inserted themselves into this case. I wish to preview to the jury and say the evidence will show that these individuals were in Fulton County custody wearing this jumpsuit, at this shirt at the time that they gave statements. That's previewing the case. There's nothing objectionable about it. I'm not going to put it on. I'm not going to jump around the table. I'm not going to do anything with it. I'm just going to show them and say this is what they're wearing.
All right. Madam.
Judge, I think that is appropriate for argument, but saying and making certain Mr. Sharp can tell the jury that the evidence will show they were in custody, all that, but that, I would argue, would be more appropriate for a closing argument. And that is argumentative.
I believe it is appropriate for a closing argument, but I think it's also appropriate for an opening argument, and I'm allowed to use demonstratives to try to get my point across to the jurors in a way that will stick in their mind, because we all know that they're going to be listening to 15 hours of or 10 hours of opening statements and 6, 9, whatever of testimony in this case.
All right, I'm going to sustain that particular objection and also remove the ask you to remove that picture of what purports to be as, I think it's a cell or something like that. So remove.
Yes.
So yes.
Remove the pictures
and lose that for the time being. Sure, for the time.
Okay, and take off the specifics.
Take off specifics. Okay.
All right. Thank you, Your Honor.
All right.
Hey, Your Honor, hold on.
Oh.
Mr. App, have your client put on his shoes. All right. Anything else? Anybody else?
Your Honor, there was not anything with respect to any of the defendants, but there was a matter that probably is best addressed with a member of defense counsel at the bench briefly. It is a short matter.
Okay.
All defense counsel?
Either one, it doesn't matter. It's not.
All right. Put your headsets on, please. Yeah, they have to also hold it. Can you hear me? Thumbs up? Okay, all right. As long as we don't have any other issues?
Thank you, Your Honor.
Okay.
Thank you, Your Honor. And I wanted to make certain no objections to Mr. Frank.
Yes, Mr. Steele, what is it?
On the PowerPoint, I'd like you to grab the newest one, and I got the last one. Number 19 is argumentative. Number 41 through 47, 51, and 54 is the law that they take from the court. I would object to those numbers.
And Your Honor, I believe that the argument about the law was raised prior to lunch.
Hold on. As it pertains to number 9, I'm going to mark the state's second PowerPoint as the next court exhibit in order.
Yes.
In terms of number 19,
that is.
We didn't chase the lyrics and solve the murder. We chased the murder and found the lyrics. Is that what you expect the evidence to show, madam?
Yes, it is.
All right. I'm going to overrule that objection. What's your next one, sir?
41.
41. Judge's rules. All right, this is a note-taking that I already gave them.
Didn't change it.
Ms. Lowe, why are we rehashing this since I've already told them that?
Your Honor, why are we putting it
Why
back?
are we rehashing that? I just told them that. I told them what was in 41, as well as 42.
Your Honor, I can take them out. I don't mind. I was just, it's part of the opening that I wanted to emphasize, but I can take it out.
I'll sustain it. You can tell. I mean, you can tell them that it's fine. I'll ask that you take out 41 and 42. So I sustain that objection, Mr. Steele. What about 49, 43? Did you have an objection, sir?
Correct.
Your Honor, is the court directing me to take out the picture, or can I just take out the word "take notes"? Because
no, take notes is fine.
Oh, okay.
He didn't object to that.
Okay.
He's objecting to 41 and 42, which I'll sustain the objections to that. And then 43, let me look at it.
Oh, okay. I'll take that out.
Okay, I have not instructed them on how to judge credibility as of yet. So the 1 through 7 would not be appropriate at this time.
Okay. So.
But you can leave in bullets 1 and 2.
Okay. So
you must remember in any way that works for you what they said on Wednesday. That's fine.
Okay.
And use whatever memory aid you need, just not to remember what you heard, but to remember who said it and how credible you found them to be when they testified, or some words to that. Okay. But the other things, I have not instructed the jury as of yet on how to judge credibility. I didn't give them a preliminary charge on that, so if you could take those out.
Okay.
1 through 7, please.
Yes, Judge.
Does that suffice, Mr. Steele?
And as...
Or do you still have an objection to 43?
And I appreciate what you said. I will accept it, but the prosecutor's opening statement, this is Johnson versus State 261 Georgia Appeal 98 Division 6C, as in Collette.
Charlie.
And Charlie.
No, just one, Charlie. Okay. Just one. We gave you the military alphabet. It's on your desk.
No, I haven't. That's why I say and Charlie.
No, I only want the military alphabet. Okay.
Well, that is not right.
I know. A very sweet lady. Okay, all right. So.
But it says the prosecutor's opening statement should be limited to what the prosecutor expects in evidence to prove a trial. So I don't see why the law is coming into their opening statement. That's my objection.
I removed 41 and 42.
For clarity's sake, Your Honor, I did and have been editing as the court has directed. So my 41, because I took out a whole slide, may be different. For clarity, the one that the court is referring to is 41. Is that the one where we are saying your assessment of a witness's credibility, blah, 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 all of that?
No transcripts in the jury room.
Okay.
I've already told them that too. So why don't you just do this?
I can take that.
Why don't you just take, your last slide can be take notes. And you can tell, I think that what you told them, what would be more than proper argument would be, hey, remember what the court told you, and take notes in a way that works best for you, and use whatever memory aid you need. And remember, that would be more than appropriate, and I think would not be objectionable.
So I'm also taking out the one that says, please pay attention. Is that what the court has directed? Because I'm going to hit delete if it is.
Yes, I would take that slide out, okay? Anything else? Can we call for our jurors now?
Same thing. If you move on 45 or the old 45, 45.
I don't have the old 45 right here. They've gone through, the new one goes through 43, sir.
Okay, as long as it's removed, then yes, I understand.
Okay.
Your Honor, and I want to make sure that we all have everything the same. So just to be absolutely certain, I'm going to share again with the court, because the numbers that I just heard the court reference.
I have the new slideshow you sent me, which goes from 1 through, I didn't go down far enough. Okay, all right. The new slideshow goes 1 through 56.
I took out some, yeah.
So I'm going to say take out 41, 42, 43.
And I'm changing them in real time, so I'm taking them out.
You need to take out 44.
Okay. Is that the one that starts with judge's rules?
No, please pay attention. You need to take out 41, 42, 43, 44, 45. I will leave in over objection. I'll let you leave in 45 and 46 over objection. 47, judge's rule, 47 needs to come out.
So the one about with the finger pointing, that
finger in the eyes are fine.
Okay. And I took out judge's rules.
I got 47.
And I think I've already taken out 47.
47 is judge's rules again.
I took that out.
Any further objections, Mr. Steele? Because I am going to leave in 45 and 46, okay? But I'll take out the other ones that you just mentioned.
Okay.
So,
My mistrial, thank you, sir.
Say again?
I apologize. Without waiving my mistrial, thank you, sir.
And your motion for mistrial has been denied, and I've noted your objection for the record, sir.
And confirming everyone has 1 through 52 with the edits that the court has directed.
It's on the same old list, right?
Yes, it is.
All right. Anything further? All right. Yes.
Just don't want to have an objection to the opening charge. We can do that later before we break for the day.
What are your objections, sir? To the court's, the court's preliminary instructions.
Is your show? First, the court talks in terms of guilt and innocence, and I would object to any phrases that you use to determine guilt or innocence. I object to the use of the phrase, the purpose of the trial is to discover the truth. No, it's not. The purpose of a trial is to determine whether the state proves beyond a reasonable doubt the allegations in the indictment, so I would object to that. I object to the fact that the court, I believe, is going to allow the jury to frame questions to provide to the court. I was unaware that the court was going to...
No, I'm probably not going to do that, Mr. Steele, Mr. Harvey. I do that because that's part of the pattern charge, the pattern preliminary charge. So And most of the 9/10 of the time, they're not going to ask any questions. And if they do, I will then present that question to you all for your consideration, and I may or may not ask it.
Okay, well, I have.
But you objected to it.
I object to the process.
Okay.
Sixth Amendment.
Anything else?
State Constitution. No judge.
Okay, all right. And I'll note your objections for purposes of the record, sir. Okay, all right. Can we summon our jurors, please?
I go ahead and share.
Yeah, put up the last slide. I believe that was Mr. Ryan.
Okay. I'm gonna go back to Zoom. This is Zoom. Did you just send it?
Yeah. You're right.
It hasn't come. It hasn't come. Okay.
Yep.
Okay. Just give me a second.
Oh, ladies and gentlemen, please be seated. We're just going to wait on one. We'll wait on one. We're waiting on one juror, ladies and gentlemen. Just be at ease. Just a second, please. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, how was your lunch? All right, good. Okay, ladies and gentlemen, before we go ahead and continue with the state's opening statement, I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right, I believe the state council earlier referred to some representation of the parties, and I just want to remind you two things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence. And with that, Ms. Love, you can continue, okay?
Thank you, Don.
All right.
And thank you, ladies and gentlemen of the jury. I'd like to report, I hope you all had a great lunch and can stay awake with me for just a few moments more. So where we left off, the crimes that the defendants are accused of committing in this case. You're going to have the indictment with you. It's going to go back. A listing of them includes the following: conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, and death by receiving stolen firearms, among other things. This list is not exhaustive. You will have again with you the indictment, and you are to consider as the state met its burden. So breaking it down, the evidence is going to show that the defendants, when we say conspiracy, it's nothing elaborate. It's a legal term, which simply means the evidence is going to show that the defendants had an agreement. It will not be a written contract presented to you. There will not be a letter signed in blood by any of the defendants. But what you will see evidence of is the defendants' actions, their presence, their companionship, their conduct before, during, and after a long list of crimes. And what you will see is that the defendants weren't always convicted of these crimes. Sometimes the state no-prossed or dismissed charges. Sometimes the police never brought formal charges. But what the evidence will show is that the defendants did commit those crimes. And when we're talking about a conspiracy, an agreement, just an agreement, unspoken agreement, we're going to participate in YSL through a pattern of racketeering activity. That's another large word that is used in the legal community, but regular folks, myself included, just don't generally tend to use it. Racketeering activity is nothing more than certain crimes, the crimes that are listed out in the indictment. You will see that, and the court will instruct you, I expect, that those crimes constitute racketeering activity. And as I stated before you all broke for lunch, a conspiracy requires just one overt act. So you will see evidence of several overt acts. Several acts that were done by these defendants and by unnamed and unindicted people as well to further the interests, to further the goal of the conspiracy that the defendants participated in. You will see overt acts meant to establish YSL's dominance and control. You will see overt acts meant to gain illegally access to money and wealth and property that did not belong to YSL. You will see overt acts, steps taken on the part of various individuals to act to protect the group as a whole. Steps that have nothing to do with a recording label. Steps that have nothing to do with an A&R executive. You will see steps that were taken solely for the purpose of illegally gaining goods for and on the behalf of YSL and its members. You will see steps taken by each of the defendants to protect the members of YSL, to establish the dominance and control of YSL. Nothing in what I expect the court will tell you, nothing in the evidence will suggest that any of the defendants had to be convicted of all of the overt acts in order for you to see that they actually had an agreement. The acts don't even have to be crimes, but they are. And that is how the state expects you will know that these defendants, they wanted to participate in this enterprise. They wanted to participate in this organization through these illegal acts. They wanted to obtain ill-gotten goods that they did not have a right to have, through robbery, through stealing, through drug sales, and the like. So we'll start off by looking at the defendants. 6 of them are at the table, and 6 of them are here for you all to decide, has the state proven its case? Rodelius Ryan. Rodelius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL in the Cleveland Avenue community. The evidence is going to show that in 2019, Rodelius Ryan was 15 years old, and that in February of 2019, Rodelius Ryan used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex and weed once they got there. Instead, when they got to the address, the female gets out of the car, and the defendant, Rodelius Ryan, and his accomplice, Damone Blaylock, also a YSL member and associate, they then came out to the car with guns. The evidence will show that Rodelius Ryan and Damone Blaylock then fired those guns into the car, where Jamari Holmes, not even 20 years old, was seated, and hit him in the back of the head with the bullet that took his life. Jamari Holmes is another one of those young lives, the evidence will show, that was swallowed up by the crater that YSL created and left in the middle of the Cleveland Avenue community in Fulton County. 12 hours after shooting and killing 19-year-old Jamari Holmes, the evidence will show that Rodelius Ryan didn't say, "I bet I make the news." Rodelius Ryan posts on his Instagram account, "I bet YSL makes the news." The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodelius Ryan was agreeing to and attempting to participate in YSL through this illegal activity. He was promoting the gang. He was showing their dominance. He was showing their power, and he was showing their control. Rodney Uten was also in the car with Jamari Holmes. That's another young life. He wasn't taken, he survived. But he was forever changed by the acts of YSL, conducting and committing violence on behalf of the entire organization. And in case it hasn't been lost on you, Rodelius Ryan's Instagram handle that he used, Slime Business Ride. Because as the evidence will show, slime is spoken and used to signify doing someone dirt. And Rodelius Ryan is proudly proclaiming his association with YSL as he talks about and as he promotes the gang itself. Rodelius Ryan's accomplice, another YSL member who's not here today, but who is a co-conspirator. What did he post after they killed Jamari Holmes? The evidence will show that Damone Blaylock didn't say, friendship over females. He didn't say laylock over buddies. He said slime over sluts. Slime over sluts while posting a YSL gang hand sign with the caption slime over sluts, a green heart emoji, and a green snake emoji, which I expect the evidence will show are the common identifiers associated with YSL. They're the identifiers that they use to announce and project themselves to the rest of the world. And then, on February the 25th, 2019, Rodelius Ryan made another posting where he's flashing cash money on his Instagram page with the caption, "Fuck YFN." YFN being a rival criminal street gang. The evidence will show that none of this was a part of what anybody has to do to be a part of a record label. The evidence will show that these acts were done in furtherance of and to promote the goals of the enterprise, the criminal street gang that is Young Slime Life. And what did the paper say? 15-year-old, they called Jamari Holmes a known gang member, but the evidence is going to show that that's not who he was to the people who cared about him most. Jamari Holmes was Jamari Holmes. He was a baby, a child, found shot to death inside a stolen car, police said. Jamari Holmes was just the latest victim of YSL's quest to maintain and retain dominance and control of the Cleveland Avenue community. Again, Rodelius Ryan didn't post, "I bet I make the news." He said, "I bet YSL makes the news." Marquavius Huey, he's also on trial for you to determine whether the state has met its burden of proving he committed the acts that are listed in this indictment. Marquavius Huey showed his agreement to participate in the activities of YSL through a pattern of racketeering activities. He showed his willingness to commit acts on behalf of the gang through his actions. The stolen handgun he had, that was the property of Jeremy Smith. Because as you will see throughout this trial, stolen handguns will become a reoccurring theme. There's no need for a legitimate organization not comprised of people committing crimes on behalf of the organization to have all these stolen handguns. Everybody has a right to have a gun, so if you're legitimate, just go get one. But the evidence will show that in this case, YSL members, stolen handguns every time you turn around. And not just stolen handguns. The evidence will show that most recently in May of 2022, where some of these defendants were found at the home of Jeffrey Williams, their leader, it wasn't just stolen handguns that YSL dealt with. It was machine guns. You'll hear evidence that at the home of Jeffrey Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch that allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun. There will be no evidence to show any need for that in legitimate, ordinary record deal making business. The evidence will show that the existence of those dangerous weapons like the machine gun, the stolen firearms, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and retain dominance, control, and ill-gotten gains. Marquavius Huey, on April the 26th of 2019, further showed by his actions, showed his agreement to participate in YSL through a pattern of racketeering activity, illegal activity. When he took the property, jewelry, money, and a debit card of Dewan Maynard by use of a firearm. Dewan Maynard, another life affected by this crater created by YSL in the middle of the Cleveland Avenue community. Marquavius Huey showed his agreement to participate in this enterprise when he struck Maynard in the face with that gun that he used to take Mr. Maynard's belongings. Marquavius Huey hijacked on October 1st of 2020 a Buick LaCrosse from yet another victim of YSL's violence, Gary Holloman, by force in violation of the law. Mr. Holloman has since passed away, not from that incident. So he won't be here to tell you what he was feeling and how he was able to tell the police who it was that committed this armed robbery. What you will hear evidence of is the extraction from Marquavius Huey's phone, where he's planning the armed robbery, where he set up with Mr. Holloman a ruse so that he could have the opportunity, along with another uncharged, unfound individual, so he could have the opportunity to put a gun in Mr. Holloman's face and rob him. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman, hey, your nephew in the Fulton County Jail, Tinquarius Mender, he needs some money on his books. So he wants me to meet with you to get money to put on his books. So Mr. Holloman, because he loves his nephew, and any friend of his nephew coming to him that way is legit, right? The evidence will show that Mr. Holloman arrives intending to meet the person so that he can give to them the money for his nephew. And to his shock and horror, he's met with the butt of a gun, two people, one with a long gun, one with a handgun, demanding his money. And that day, as the evidence will show, Mr. Holloman wasn't the only person affected by the violence perpetuated every day by YSL. Delmisha Coppage, she just happened to be on scene. She just happened to be right there conversing with and talking to Mr. Holloman when the defendant and his accomplice came up, held them at gunpoint, and demanded their belongings. You'll hear how they directed Delmisha Coppage to just sit on the ground, just give me your stuff. You'll hear how they robbed Delmisha Coppage at gunpoint. The evidence is going to show Mr. Huey's tight relationship with their leader, Jeffrey Williams. The evidence will show that Mr. Huey, on various occasions, checked in with, reached out to Mr. Williams to see, hey, I got this stolen item. You want first dibs on it? Marquavius Huey's actions that betrayed his agreement to participate in the conspiracy didn't stop with Gary Holloman and Domisha Coppage. The evidence will show that in November of 2020, he made terroristic threats towards Justice Woodard after Woodard told Mr. Huey she'd see him in court. He said, "You will die if you put the police on me." Showing their association, showing their agreement, showing their intention to participate in this organization, this enterprise through a pattern of racketeering activity. The evidence will show that while fellow associate Tinquarius Mender was an inmate at Fulton County Jail, Mr. Mender, Mr. Huey, and Mr. Williams conducted a recorded video call wherein Mender relays he needed something and Williams pointed to Mr. Huey to take care of it, and then flashed Mender the YSL sign. You see, it's not a crime to flash a YSL sign. The evidence is going to show it's not a crime to participate in a video call. The evidence is going to show that it is not a crime to endeavor to provide something for a friend who's locked up in jail. All of that is okay. These acts aren't listed on the indictment because they're crimes. They're listed because they are actions. Actions that the legalese for is overt acts that reflect each of these defendants' tacit or unspoken agreement to participate in this enterprise through a pattern of racketeering activity, to be a part of this group, to gain ill-gotten goods through crimes listed in this indictment. I don't even have to use the word racketeering. I don't even have to use the word conspiracy. They endeavored to do some illegal stuff to get a bunch of stuff that didn't belong to them. And somebody, more than one, but all we need is one, the evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after however long it takes us to get there, and you're looking at 191 acts and thinking, state, really?
I sustain the objection.
Thank you, Judge. I'll move on.
Move on. That's argument.
The evidence is going to show that these steps that they took are akin to you just going out and get some toilet paper to further a conspiracy to go TP a house. Doesn't have to be a crime. It's just an act, an action. The evidence is going to show that the defendant Jeffrey Williams' words and actions also betray his participation in the conspiracy. I expect that you will hear from a YSL associate and member at trial that the defendant Jeffrey Williams rented a car, notwithstanding that Jeffrey Williams had his own cars, but he rented a car which happened to be a silver Infiniti sedan that other YSL members, among them Demonte Kendrick and Shannon Stillwell, used when they openly and notoriously gunned down Donovan Thomas on January the 10th of 2015. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffrey Williams paid them money, gave them money to go to Miami and lay low. in the wake of the Donovan Thomas murder. Later that month, on January the 26th of 2015, Demikion Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, he posted a video of the defendant, Jeffrey Williams, looking into the camera and saying these words. So, I think lie to their mama, lie to their kids, lie to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise through illegal activities.
Hey, good afternoon. We are coming to you live as we continue our coverage of the memorial ceremonies for former First Lady Rosalynn Carter.
Right now, the Carter family motorcade just arrived at the Jimmy Carter Presidential Library in Atlanta, and that's where Mrs. Carter will lie in repose until tomorrow morning. You see the honor guard right there. Now, tonight, the public is invited to pay their respects to the former First Lady, and we will be covering all of these events for you in the several days that we will be honoring the life of Mrs. Carter.
And you know, this morning we saw a lot of...
They're investigating, they're finding out who committed it, and after doing all of that, they happen upon lyrics. Lyrics that have an uncanny similarity to very true and very real and quite specific events, as the evidence will show. Jeffrey Williams' words that he promotes through songs with beats behind them, they aren't random. He tells you, as the evidence will show, take this shit to motherfucking trial. I rep my life for real. For slimes, you know I kill. Trial, I done beat it twice, Kendricks. I'm undefeated, like feds came and snatched me. I don't know, no point in asking. I was on what? Bleeding. Stuck like a magnet, bitch ass nigga. I shoot at your man, you need to stand down. I up my stamina, take it to trial. Get an appeal, take it to trial. Yeah, you're gonna whack 'em. Pay for that casket, that's just if we whack 'em. My young niggas pulling up. Bentleys, Austin Martins, Rares and Teslas strapped with an FN. You're gonna hear a lot about FNs. FNs galore. From here to 2015, FNs all throughout the incidents that are involving gang members, YSL. Watch me whack that bitch. Pop him like assist. Glock with the assist. Incidentally, the gun at the home of Jeffrey Williams on May of 2022 that had been modified with that switch, it was a Glock. Again, we didn't chase the murders. We didn't chase the lyrics, rather solve the murders. We chased the murders, as the evidence will show, and in the process, we just found the lyrics. Jeffrey Williams' words and actions further reflect his agreement to participate in this organization through this criminal activity. He tells you, we committing them crimes. Hop out and shoot. Roll one up for the gang. He's not using gang colloquially. The evidence will show he's telling you they are a gang. You want to be slime? Children of Fulton County, go catch you a body. Me and Lil Bro. The evidence.
How would you expect evidence to show, madam?
It is indeed, Your Honor.
All right, I'll overrule the objection.
evidence will show that when Jeffrey Williams is saying, me and little bro, we used to steal from the store, we had to stick it and go. He's talking about himself. The evidence will show that this is the manner, through the music, that he has been blessed with the opportunity to be able to release and gain wealth from. Through that music, through that blessing, the evidence will show that Jeffrey Williams led the group of people that wreaked utter havoc on Fulton County. Jeffrey Williams' words and actions, as the evidence will show to the members of his gang, you'll hear in a conversation he has with them, y'all ain't beat him up or shot him yet, y'all he's getting soft. The evidence will show that there's no place or need for that kind of edict or statement when all you're doing is making music. And to clarify and put a very clear and fine point on it, the evidence will show that no one is attempting to take away from Mr. Williams the fact that he has had a lucrative rap career. The evidence is simply being put before you to show that he is guilty of committing the crimes that are laid out in this indictment. That he and his fellow YSL gang members and associates on trial before you now agreed to participate in this organization through the illicit, illegal activity listed in this indictment. And that they further committed all the other crimes listed in the indictment beyond count one. Because as you'll see, count one consists of 191 overt acts. Acts that aren't all crimes, they're just acts. But counts 2 through 65, the ones that have these defendants' names on them, are the ones you're here to evaluate whether or not the state has proven. Actions and words, words and actions. The evidence will show that this was Donovan Thomas in life, that on January 10th at 2:15, about 7 o'clock in the evening, Donovan Thomas was living his best life. He was up at the barber shop at 330 McDaniel Street. He had paid for a bunch of people, a bunch of kids to get their hair cut. And you'll see that he is out there enjoying himself. The last actions that he took while he was fully alive and healthy, joking with his friends. You'll see that they didn't even see it coming. You'll see evidence that Donovan Thomas was literally in the middle of lapping it up with his friends when a car drives by and opens fire on him and whoever else might have been in close proximity to him. The evidence will show that this act wasn't done secretly. It was done openly, notoriously, almost as if to send a message. We did it. The evidence will show everybody knew who did it, because it wasn't done secretly. The evidence will show that this act didn't happen in a vacuum. There were things that led up to it. An argument at Club Crucial or Club Brucial, as my defendants may like to say, that involved a YSL associate by the name of Kenneth Copeland and a member of a rival gang. Kenneth Copeland gets jumped He's flashing money because that's what they do. It's ladies fight night and they're out there flashing money. Kenneth Copeland gets jumped. Diamante Kendrick jumps into action, goes to Kenneth Copeland's defense, punches out a member of the opposition, and then shots are fired. Shell casings. Shell casings are all throughout the evidence that you'll see and hear in this case. Remnants of the violence inflicted on this county by YSL and its actions. Shell casings are fired in between January the 6th and 7th of 2015 and January the 10th. Other incidents take place and they lead to the ultimate gunning down of Diamond Thomas. As the evidence will show, in the ensuing months, there were series of shootings and retaliatory shootings. Most notably, the mother of rapper Rayshawn Bennett gets shot. Her house is shot up twice. She gets shot one time. And the evidence will show that there is not always cooperation, because there is a code that people adhere to when this type of violence is surrounding them. No snitching. So the evidence will show that even as people were getting shot, even as people were bleeding, even as people were being taken to the hospital to have their wounds attended to, they weren't always forthcoming. They weren't always willing to talk to and to trust law enforcement, not even if it would serve their own purposes. The evidence will show that members of YSL ultimately, as a result of those shootings and retaliatory shootings, ballistics or firearms matches started coming back to various people. And then one YSL member, Quindaria Zachary, he gets caught with a gun. The shell casings from that gun go to match some of these shootings. Quindaria Zachary is caught. He starts telling. The evidence will show that Quindaria Zachary was a straw purchaser for YSL. A straw purchaser is nothing more than somebody who goes and gets guns for somebody who's not supposed to have them. And that's what Quindaria Zachary did. Firearms found in the hands of Kenneth Copeland led to further revelations to the police and law enforcement. The evidence will show members of YSL were so eager, so gangster about acting on behalf of and in the protection of the defendant Jeffrey Williams and YSL that when Wayne Carter, otherwise known as Lil Wayne, came to town to perform at the compound while the defendant Jeffrey Williams was performing in Lil Wayne's hometown, according to word from the people that talked getting booed at the time, members of YSL show up at the compound, locked and loaded with guns. Evidence will show that security knew to be on the lookout for members of YSL. The authorities were alerted to ongoing public rifts and back and forth between the defendant, Jeffrey Williams, and members of his gang, and statements being made publicly on social media about, towards, and threatening Wayne Carter. So when Tyrone Dennis, who is working an extra job, he is a law enforcement officer. At the time, he was an investigator with the Atlanta Police Department gang unit. So when he's there working his extra job, and he sees Walter Murphy, one of the founding members of YSL, show up with the defendant's sisters and Trontavia Stevens and ultimately Jimmy Winfrey with guns. When he sees Walter Murphy try to secret a gun underneath the wheel well of a car, he calls him out. He's like, what are you doing? Walter Murphy's like, oh, hey. The evidence will show that the YSL gang members that showed up at the compound that night were not allowed entry into Lil Wayne's concert, his venue. So what they did was they waited until Lil Wayne leaves, gets in his tour bus, and is attempting to leave the area. They get up beside the tour bus and they unload bullets into the man's tour bus. Bullets. For nothing, except to show their dominance. There will be no evidence that Lil Wayne threatened either of them that night. But that act on the part of Jimmy Winfrey and the defendants before you today, that act was intended to show their solidarity, their willingness to act on the behalf of, their willingness to exact violence upon anyone who threatened the position of the criminal street gang calling itself Young Slimelight. You'll hear evidence that after being arrested, or actually when he was approached back in 2014 about an armed robbery he allegedly committed, YSL member and associate Trontavia Stevens was seen bearing tattoos on his hands, ROCCREW, Cleveland Avenue. And that on his side he had YSL. And Detective Mark Belknap inquired of him, what's that? Bill Belknap knew because he had been working the streets of Atlanta for a long time. He was familiar with Right Crew. But as gang investigators, they're taught to interact with and talk to people when they see indicia of criminal street gang activity. You'll hear that Trontavia Stevens told Belknap, well, Rock Crew is the name we used to call ourselves. Then we started going by YSL, which stands for Young Slimelight, or it did stand for Young Slimelight. But then, when my friend Jeffrey Williams started becoming successful, we changed that name to Young Successful Life. The words of a member of the gang himself. The only time, as the evidence will show, that members of YSL don't want to call themselves and acknowledge that they are in fact a gang is when it would be to their detriment. The evidence will show that any other day of the week, they are loudly and proudly promoting their criminal activities. Donald Thomas, he was driving this Chevrolet Tahoe the night he was gunned down. The evidence will show that this location here is the barbershop right up from the Texaco at the corner of McDaniel and Northside Drive in Atlanta, Fulton County. We asked you during voir dire, you heard us say, how many of you are familiar with this area? This is that area. The evidence will show that that is the way that Donald Thomas looked last time his loved ones saw him. That his life was swallowed up in that crater created by YSL in the Cleveland Avenue community. And the words that they found while looking into this murder, spoken by members of YSL. We don't speak about shit on wax, but indeed maybe they do, as the evidence will show. They just kind of thinly veil it. We are known to kill the biggest cats of all kitties. Donovan Thomas in the community, he was a big homie. He was a friend to a lot of people. He was a big deal. And it touched a lot of people, as the evidence will show, when his life was taken. The words that were spoken, we known to kill the biggest cats of all kitties. How coincidental that Donovan Thomas was gunned down. And these were the words later spoken by members of YSL. The evidence will show that it's not coincidental at all. 100 rounds in a Tahoe. 100 rounds in a Tahoe. The evidence will show that the lyrics released by YSL members, the lyrics they chose to speak, they bore a very eerie significance to real life. 100 rounds in a Tahoe. And you'll see that Donovan Thomas's Tahoe had bullet defects all along the back of it when they sprayed Donovan Thomas and his car on January the 10th of 2015. This that slime shit, killing 12 shit. The evidence will show that 12 is the word that is commonly used to denote law enforcement. And speaking of the young people whose innocence and whose lives were swallowed up by that crater created by YSL, Christian Eppinger. He's not before you today, but he is a co-conspirator of these defendants. He is a YSL member and associate who got YSL tattooed on his face at the tender age of 15. He repped YSL continuously and notoriously throughout his social media. The evidence will show that at the age of 16, he, along with an accomplice, robbed a young woman by the name of Taradia Hill at gunpoint in front of her child. And that at his sentencing hearing, Taradia Hill, seeing a young black boy, who could have been her brother, cousin, she actually advocated for Christian Eppinger's lenient sentencing. So Christian Eppinger, he wasn't sentenced on what he was originally charged with. With the acquiescence of the victim, Christian Eppinger received a lesser sentence. He went to prison for a short time, and within less than a year, he committed an armed robbery. And when law enforcement officers are out there looking for Christian Eppinger, who incidentally constantly posted on social media with the guns and his gang signs and the green emojis with the gun pointing to the camera or to some other emoji talking about how he reps hard for YSL. When law enforcement officers, specifically a law enforcement officer just 30 years old by the name of Officer Rogers, when they go to apprehend Christian Eppinger on this armed robbery he committed after being released from prison, having robbed Taradia Hill, they do everything they can to take him in without causing any harm to Christian Eppinger. But you will see that while he's being taken into custody, what Christian Eppinger does, he takes the firearm of this young officer. He pulls it out of the holster and he fires, putting 7 bullets in Officer Rogers. The evidence will show leaving a law enforcement officer with PTSD after he has tried to humanely apprehend a member of YSL. The evidence will show that this person depicted here is Quantavious Greer, also an associate, but perhaps more importantly, the brother of the defendant Jeffrey Williams. Christian Eppinger was so deeply entrenched, ingrained with, loyal to YSL, he's even posting free bitch as Quintavious Greer served a sentence for murder. Who said they want smoke? Christian Eppinger, as he's calling himself YSL Briss. Note that Chris does not start with the letter B, but it does when you're associating yourself with a criminal street gang who aligns itself with the Bloods. And that's the tattoo that Christian Eppinger on the side of his face proudly publicized on June 27, 2015. He wasn't even 16 yet. New ink with the green snake emoji and a red heart. The evidence will show that though you'll hear over and over the names of the 6 people on trial before you today, that the 6 people on trial before you are not the people who were most viciously affected by the acts of this criminal street gang. The evidence will show how far members of YSL are and were willing to go to act immediately on behalf of each other. Dexter Montgomery, minding his business, happened to drive in just a little too closely behind another YSL associate, who then phoned up the gang who was posted up at the trap house. And in minutes, 2 more YSL associates showed up with a long gun and handguns. Dexter Montgomery had no idea he was about to lose half of his head that day. As Dexter Montgomery left the gas station, 2 YSL associates followed behind him. And as he stopped at a red light, they opened fire. Miraculously, the evidence will show that Dexter Montgomery survived, but literally half of his head is gone. You'll hear from and see Dexter Montgomery during the course of this trial. The evidence will show that after that happened, law enforcement, at first it wasn't the gang unit, but the gang unit recognized some of the players, Walter Murphy, other members of YSL. And so they began to assist in the investigation. And they learned, the YSL gang members said, we got a call that one of us needed some help. He didn't know who this was pulling up behind him, so we just responded. You'll hear that investigators, Gaither and Dennis, said, well, wait a minute, did you know what you were responding to? They're like, no, we don't have to know. If our boy needs help, we're gonna respond. They said, well, where'd you get the gun? Oh, they're by the door of the trap house that we were in. They're just there, ready for us to use when we need to. Their words, I can't make it up. The evidence will show that actions of YSL gang members and associates on behalf of their leader when they felt someone disrespected Jeffrey Williams or any other member of their pack, they made threats. Not quiet, whispered threats, loud, public threats with wide, vivid displays of firearms. We're not going back and forth. This about to be some Biggie and Tupac shit and shooting up Wayne Carter's tour bus. The evidence will show that all of those actions, they're not elements of the offenses that are charged in the indictment. We don't have to show those things in order for you to find them guilty, but the evidence will show that those things prove the existence of the conspiracy, of the agreement itself. The agreement on the part of these defendants and other charged and uncharged co-conspirators to be a part of this organization known as Young Slime Life through a pattern of this illegal activity outlined in the indictment. There are numerous victims that you're going to hear about. Shannon Stillwell is another defendant who is before you, being accused of various crimes in this indictment. Shannon Stillwell is alleged by one of his own crew, by another YSL, two other YSL members, to have been one of the gunmen who took the life of Donovan Thomas. The evidence will show that Shannon Stillwell was arrested. He was arrested after some investigation by the Atlanta Police Department. The evidence will show that the information initially relied on by that first arresting officer, it didn't pan out to be actually accurate. So when the case got to the district attorney's office, more investigation was conducted. The evidence will show that the office didn't just take the word of the person who originally identified certain people as having committed the murder of Donovan Thomas. Instead, as the evidence will show, what our office did was dig to find out whether the people who were talking were actually in a position and a place to know the stuff that they talked about. And what they learned was that that person originally relied on by Investigator Thorpe, that person was just lying. And so the people that Investigator Thorpe originally arrested on the Donovan Thomas murder, they were released at various times on bond as the office continued to investigate further. The evidence will show that our office did not just stop at the word of one YSL member. The evidence will show that yet another accomplice corroborated the words of the first YSL member that talked. The evidence will show that cell phone records further corroborated the information law enforcement was getting from these people. And ultimately, Shannon Stillwell, Demonte Kendrick, Justin Cobb, Javoris Bradford, they were all indicted in this particular instrument that you'll have for your consideration. But the only two people who are in front of you for you now to determine whether or not the state has met his burden are Demonte Kendrick and Shannon Stillwell as it relates to Donovan Thomas's murder. However, between the time that this indictment came down and the time that our office decided, no, we need to look into this investigation some more, Shannon Stillwell was released from jail. But he had to wear an ankle monitor as a condition of his bond. The evidence will show that during the time in 2015, after a lot of arrests were made following the murder of Donovan Thomas, that the violence in Fulton County, the gun violence that had continued over the course of that year, it kind of subsided a little bit.
Basis. I sustain the objection.
Yes, Your Honor. The evidence will show that around 2019, 2020, law enforcement investigators, they started noticing some activity on the part of gang members. They started paying particular attention. One of those investigators was investigator Marissa Vivarito. You'll see and hear from investigator Vivarito, and you'll learn that one of her jobs as a law enforcement officer, one of her background experiences was that she was a probation officer, so she had a lot of information about a lot of YSL gang members. You'll hear that initially, after Shamel Drinks was gunned down, Detective Hogan with the Atlanta Police Department, he didn't have any leads. As a matter of fact, he came back to the precinct lamenting the fact that he had no leads on this homicide that just occurred at Windsor and the I-20 entrance ramp. Young man killed, gunned down inside his car. When investigator Vivarito began talking to Detective Hogan, she saw that Detective Hogan did have some footage from the gas station right up from that location. And that investigator Hogan was looking to find the people in the gas station because that gas station was the last place that Shamel Drinks was seen alive. One of the people in the surveillance footage was wearing a very distinct hoodie and coat. And as it would happen, investigator Vivarito had hours earlier been at a Waters Road location, one of YSL's hangouts. As the evidence will show, a place from which they conducted transactions, and that the Waters Road address had been shot up, and investigator Vivarito happened upon Shannon Stillwell and other members of YSL in the same outfit he was seen in the surveillance video on at the time Shamel Drinks was inside the gas station. The evidence will show that further investigation revealed that Shannon Stillwell was wearing an ankle monitor at the time that Shamel Drinks was gunned down. And that ankle monitor put him right there at the place that Shamel Drinks took his last breath. The evidence will show that in this murder, much like in the Donovan Thomas murder, there was a rental car involved. A rental car which these defendants had gone and gotten the windows blacked out, tinted on, earlier the day that Shamel Drinks was gunned down. Tinted the windows of a rental car. The evidence will show that it was to evade being seen by the opposition. The evidence will show that as a result of all of this violence and activity, during the midst of it all, investigator Vivarito had secured a wiretap for Demekion Darlington, YSL gang member and associate. She was able to listen and detect hours of the goings-on of the enterprise. She learned throughout the course of her own investigation and during her time looking into YSL that a rival gang member, Rayshawn Bennett, ended up at the Fulton County Jail at the same time YSL gang member Jaden Myrick was there. The evidence will show that Jaden Myrick, upon seeing Lucci, reaches out to get permission from King Slime to take Lucci out. The evidence will show that Jaden Myrick actually endeavored to stab Rayshawn Bennett to death, but that he was unsuccessful. The evidence will further show that Jaden Myrick wasn't the only one reaching out to this defendant, Jeffrey Williams, for permission to commit a homicide. Looking at Shannon Stillwell's words along with his actions, happening upon the lyrics while trying to solve the murder, the evidence will show that law enforcement found one nugget spoken by Shannon Stillwell. I just beat a murder rap. Paid my lawyer $30 for that. After he was released on bond for the murder of Donovan Thomas. And before he actually took the life of Shamel Drinks. The evidence will show that the young man on the left is Shamel Drinks in life. And that the photograph on the right is what was left of Shamel Drinks after YSL and the crater it created in the middle of the Cleveland Avenue community took that life from his family, friends, and loved ones. I said a lot, and I'm not the only one you can hear from today. So you might be happy, I'm about to sit down. I want to ask you to make use of those notepads and those pencils that you have in your possession. The court's already given you the instruction. Take notes. Rely on your memory. Use the notes to document and help you remember after you've heard weeks and weeks and weeks and scores of witnesses who said what. I expect that as you listen to and evaluate witnesses who come in to testify, there will be witnesses who you discover changed their stories from the time they first made a statement to the time they actually had to appear here in court, in public, and tell them folks. I expect that the evidence will show that there are some witnesses you will assess are just scared. Some are embarrassed, some are intimidated, some don't want to remember, some just plain don't remember. The court alone gives you the law on how to deal with and how to assess those witnesses. I only ask that you follow closely the instructions that the court gives to you. Look at who the witnesses are. Look at who they look at while they're on the stand. Who they don't look at or won't look at while on the stand. Look at how they answer questions posed to them from the state versus questions posed to them from the defense. And if the occasion arises that you find that a witness as presented in court says something different than what they said previously, you determine why it is you believe that they said something different once they got in court. Words and actions. The defendant's actions coupled with their words. They prove the existence of the enterprise. Their actions and their words, the evidence will show, proves their agreement to participate in this enterprise through these illegal activities outlined in the indictment. Preserving, protecting, enhancing the reputation, power, and territory of the enterprise through acts including murder, assault, and threats of violence are what the evidence will show these defendants did over the last 10 years. The evidence will show that the violence didn't stop in 2015. preserving, protecting, and enhancing the reputation, power, territory of the enterprise by the posting of messages, images, videos, and songs demonstrating their allegiance to the enterprise and willingness to engage in violence on its behalf are what you'll see evidence of over the course of the next several weeks. Maintaining armed individuals ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. It's what the witnesses and the evidence you will see proves to you. Obtaining money and other property through illegal activities like robbery, theft, and illegal drug sales and distribution. And obstructing law enforcement, killing 12 shifts. Investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. You'll see it for yourself. The children whose innocence this organization claimed as its own. And in the end, the evidence is going to show you that YSL is a legal enterprise, nothing fancy about it. The evidence is going to show you that it's also a criminal street gang. Those two are not mutually exclusive. That these defendants participated in this enterprise in a way that had nothing at all to do with the record label, except maybe their actions as reflected in their songs made their music more real and perhaps more appealable to somebody. The evidence will show that the defendants, they talk about YSL while they talk about the crimes they committed. And while they talk about the crimes they're going to commit, you'll see that this evidence proves that YSL is a criminal organization. The defendants have been associating together for many years, committing crimes together against the general public, against rival gang members, as the evidence will show, against law enforcement, and against each other. The evidence will show they agreed, they willingly participated in these activities. In the end, the court has told you and will tell you again that you are to evaluate the evidence and apply that the law the court gives to you to that evidence and render a verdict that speaks the truth. I expect that at the close of this evidence, you'll see that the defendant's presence, companionship, and conduct during all of these illegal activities, their words and their actions not only show the existence of the criminal enterprise called YSL, it also shows the conspiracy. And in the end, we're going to all come back and make our arguments to you. But the one thing that I'm going to be doing, our team will be doing, is asking you to uphold your duty and render a verdict, the only verdict that speaks the truth, and find these defendants guilty of each and every crime listed on this indictment alleged against them. Thank you.
Ladies and gentlemen, we've been going a minute. You want to take a comfort break? Anyone? All it takes is one, okay, all right, two, see, and then everybody else will go after that. Let's take 10 minutes, and then whoever next would like to make an opening statement, I'll offer that to them at that point, okay? All right, so we'll be in recess for 10 minutes. Remember my admonitions to you. All right, we're in recess. Got no court reporter.
The issue of elections.
I got no court reporter.
I understand.
All right.
Your Honor, if it's all the same to you, it doesn't need to be on the record for mine.
It does.
Okay.
It needs to be on the record for me.
All Sergeant Ingram, do we have everybody back present, sir? Can I get all our attorneys to please kind of start making way toward your seats, please? Thank you, sir. All right. Have we checked on our jurors? Are they all ready, sir?
Yes, sir. Yeah.
Okay, all right. Mr. App, what do you need?
Your Honor, my understanding, I planned my opening arguments around I'm not using any PowerPoints. I didn't turn any of the state because I planned my opening arguments around using just paper and notes to speak to the jury off of, with the understanding that I was going to have a lectern to speak, to put those papers on in front of the jury. And my understanding was from Mr. Steele that there was a conversation with Captain Kendall last week that a lectern, which is in the hallway, would be allowed to be placed up there so that then those papers could be used. I understand now there's some disagreement or understanding about whether a lectern that's out there can be used or not.
I wasn't involved in that particular conversation, but I want to say that also, in order for us to for you to be heard, my suggestion is you probably use the podium. And there's plenty of room on the podium, that particular podium that's immovable, and it's also got a microphone. And you're welcome to walk back and forth, sir. You can walk around the well. I'll give you permission to do so. You won't bother me.
So I can tilt this.
There's a sign on it. Do not move. Do not move. Do not. Yeah, because it's part of our evidence presentation system.
Well, there is a lectern on wheels that's 20 feet away from here that if we could just move it into the... Well,
you've also got the challenge of you've got some jurors there available, so jurors that are sitting there closer, so I prefer you not do that, okay? You have to do the best you can with the table you have. Like I said, you can walk around. You can even put some of your stuff on the edge of the state's table if you'd like to. And also, related to that, if there's anybody in the media that is zooming in on anything that's involved on any council table, please do not do that, okay? If you are, don't do it. So just please, I just wanted to make you all aware of that, all right? So, Mr. App, if you'd like to, since all this furniture belongs to me, technically, you are free to put your whatever you need on the edge of the state's table.
Can I use the witness stand when I'm giving my...
Yeah, sure. Absolutely.
I'll make it work.
Absolutely.
I prefer the lectern, but I'm...
Yes, Mr. Sharp.
As the person who spent most of this morning trying to procure a lectern, there's also...
You didn't tell me, though, and we could have gone through this earlier.
I spoke to Captain Kendall last week. I spoke to numerous members of the Sheriff's Department this morning, and I was going through every procedure that I was supposed to go through.
Well, ultimately, it's my decision, right?
I understand.
Okay.
There is a much smaller lectern that can easily be picked up and placed here in courtroom 1D. It would literally take 2 minutes.
Sir, I want to move the presentation of this evidence. We could have discussed this weeks ago, and we could have gone ahead and planned it. I could have brought it over here and test drove it, but you didn't give me that opportunity, so let's move on.
Okay.
Thank you. Anybody else?
Judge, do you know what time?
No,
6 o'clock?
I don't know what time we're going to. But I'll let you know as soon as, I'll figure that out in just a little bit, Mr. Steele, okay? All right. Who's making the opening statement next, if so?
That's me, Your Honor.
Okay, all right. Let me know when you're ready, sir.
We're just going to set up on Zoom.
Okay, all right. Let me know when you're ready.
Your Honor.
Yes, Miss Act.
I'm good. I'll see you on
Kokomo is helping with the...
That's fine. That's fine.
Thank you.
That'll work out. And Ms. Weaver will yield some space to you, so, okay.
Being most accommodating.
There you go. We aim to please.
Oh, man.
I sent them to you. I think I emailed the first two to you, but I don't. The second two, Chris, Miss Love's going to have to send them to you because they're password protected. So if you ask her to send those to you, she can. I went ahead and You ready, young man? I think he said he's ready.
Oh, you ready?
Okay, all right. Can we summon our juror, Sergeant Ingram, please? All right. Please be seated. All right, thank you, Sergeant Ingram. All right, does any member of the defense wish to make an opening statement this time?
I would, Your Honor, on behalf of Mr. Still.
All right, Mr. Sharp, you may proceed, sir.
Thank you, Your Honor. May it please the court. Good afternoon. Good afternoon. My name is Max Sharp. And along with my co-counsel, the gentleman with the white hair back there, his name is David Botts. And together we have the honor and privilege of representing Shannon Stillwell. Shannon Stillwell is an innocent man. He's been accused of the murder of Donovan Thomas in 2015. He is not guilty. He's been accused of a murder of Jamal Drinks in 2022. He is not guilty. He has been accused of conspiring to violate the Georgia State RICO law. He is not guilty. Now, I am going to deliver an opening statement that will preview what I believe and what I believe the evidence will show in this case and the evidence that will come in trial. But before I even start previewing what I believe the evidence will be, I want to discuss with you some preliminary matters regarding this case. The first preliminary matter that I wish to discuss is my client's name. Okay? On the indictment, you will see, when you look at the indictment, that my client is listed as Shannon Stillwell, also known as Shannon Jackson. Okay, and there's a simple explanation for that. You will learn that his mother was a Stillwell, but he was raised by his paternal grandmother, Betty Jackson. So at times he's been a Stillwell, at times he's been a Jackson. He's indicted as Shannon Stillwell. I know him as Shannon Stillwell, but throughout this trial, some people may say Shannon Jackson, some people may say Shannon Stillwell. I may slip up and say Shannon Jackson. But we're talking about the same person, Shannon Stillwell. Second preliminary matter. It has not been lost on me that my client, it's not lost on any of us, that my client is charged with 2 murders in this case. He's charged in 2015, and the evidence will show that he was wrongfully accused. And that case never went to court. He was accused in 2022, wrongfully, based largely on assumptions made about the 2015 case. We plead absolutely not guilty. With our backs straight and our eyes wide open, we plead not guilty to those charges. And finally, ladies and gentlemen, as far as preliminary matters, as you probably have realized through jury selection and the fact that we have some visitors from the press here today and different things about this case, this is somewhat of a unique case. It's drawn some attention. But the thing I want to stress is that this case is no different than any other case in the state of Georgia or the United States of America as far as criminal cases go. And it has the same ground rules as any other case tried in this great union. The ground rules of this case are that the defendant, Shannon Stillwell, and all the other defendants are presumed innocent. The state bears the burden of proving their case against all the accused individually. And the state's burden of proof is the highest burden in our system, beyond a reasonable doubt. Beyond a reasonable doubt. Ladies and gentlemen, the state started talking in their opening about about colors. About colors and hand signs and different markers and gang activity and all the rest. And I anticipate that the state will attempt to bring in colors and their belief about what colors mean in this case. Throughout this case, I'm going to ask you to focus on a couple colors as well, just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. And the evidence in this case will show that many of these young men grew up without dollar bill green. The evidence will show, and you'll learn about different areas of Atlanta, Capitol Homes, Jonesboro South, places that have since been revitalized in some ways, but back 15 years ago were not nice places. Despair, lack of opportunity, poverty, lack of positive role models. You'll hear about Shannon and his upbringing. You'll hear that he grew up in the Forest Cove apartments, which have since been condemned. And he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother who had succumbed to drug addiction, and it was his paternal grandmother, Betty Jackson, who raised him. And she raised him in the Forest Cove Apartments, and you'll hear that she loved him, poured love into him, called him her sweet thing, and he called her Mom because she was Mom. You'll hear that despite the love and guidance that Miss Jackson tried to pour into Mr. Stillwell, at the age of 14, without other people providing him guidance, he dropped out of school. And he decided that he wanted to be a rapper. You'll learn about the rap industry in this case. Then you'll learn, and you probably already know this, but becoming a rapper is not the same as signing up for a job at Home Depot, where you work for 2 weeks and you get your first paycheck. When you're chasing superstardom in the rap game, those paychecks might not come for a long time. And sadly, they may not come at all. It might be a dead end to nowhere. You'll learn about the vast numbers of young men with the same dream as Shannon and how the supply of potential rappers greatly exceeds the demand for superstar rappers. That was really a bad occupation to try to get into when it really comes down to it. But Shannon was 14. And you'll hear how he tried to hone his skills and try to make it in the rap game. But you'll hear that Shannon, like many other young men chasing this same dream, weren't making any money. And bills have to be paid. And kids have to eat. And rent becomes due. In this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green for Shannon and many others. That type of green, that shade of green is called bud green, which is actually a color. You can paint your house bud green. But in this case, of course, bud green stands for marijuana. And you'll hear how Shannon, trying to make it in rap, sold marijuana. The state has alleged in their overt acts, okay? These are acts that they claim prove that there's some RICO conspiracy afoot. You'll hear that on August 23rd, 2013, Shannon was charged with possession of marijuana with intent to distribute, approximately 1 ounce, over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July of 2015, he was charged with possession of marijuana with intent and possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwell has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm, which is always synonymous with selling drugs. Okay. These are his path, his past, his truth, and they were his decisions. His motivation was to make money for him, to live, to pay rent, to eat. Ladies and gentlemen, we're not hiding from the past. But the evidence will show that Shannon's decisions, starting over 10 years ago, had nothing to do with YSL or any other organization. You won't hear evidence that Shannon was selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization, or calling Jeffrey Williams and saying, hey, I got some money for you, man. No, it was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL. Has nothing to do with the January 10th shooting of Donovan Thomas. And it has nothing to do with the 2022 shooting of Shamal Drakes. On count one, on this indictment, the state charges Shannon Stillwell with conspiracy to violate the RICO Act. They say on or between January 24, 2013 and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering. The state in their opening said, further the interests of YSL, further their goals. They also said they endeavored to do a lot of stuff to get them a lot of stuff. Okay, it's a little bit more complicated than that. And in RICO, the actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table before his studio time to chase his dream as a rapper. I'm going to ask you, as a close of evidence, to find Shannon Stillwell not guilty. Count one. Okay. The other color, besides dollar bill green and I guess bud green, that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County blue refers to the jumpsuits that these individuals wear, the county-issued jumpsuits that are typically navy blue, a deep navy blue, and say Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular, and common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small cell with you. You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger. You're separated from your family and your loved ones. But most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case because the state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell, when they became involved in this case, they were all wearing the Fulton County blue. When Darius Zachary, Kenneth Copeland, Sammy Davis, Tremont Stillwell, Spencer Wright will hear them testify if they're called. You'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or when they claimed they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue? When they no longer had control of their destinies and they needed a favor. And they decided to insert themselves into a high-profile case that could solve all their problems. Let's talk about January 10, 2015. That's the case involving Mr. Thomas. And the evidence will show that this was a high-profile case. And the reason, this is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gang leader, that he was the leader of the Inglewood family Bloods in Atlanta, that he was high-ranking. And that's what made this case a big deal on the streets. You'll also hear that this case, this shooting of Donovan Thomas, was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you'll see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know. But he was with other individuals in a parking lot in between two barbershops. One being Mr. George's barbershop and one being Mr. Bernard's barbershop. And you will hear that this car zoomed down this dark street on that January 9th, and it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night. A matter of seconds. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015, and you'll hear that he gathered the evidence from the crime scene. There was no DNA, there was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. And you'll hear that this case remained unsolved. No one had been charged for 9 months and 9 days. On October 19, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You will hear that he contacted Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview. How he gave his vantage point to Detective Thorpe. How Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barbershops. And you'll hear that Nicholas Robinson told Detective Thorpe
that he saw it all. And he saw the people that were inside the car. And he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out of the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Demetrion Garlington. He was the driver of this car. Quindarius Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwell, my client, in the back, passenger side, shooting a handler. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge and then a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge, and next to the picture of Kenneth Copeland, and next to the picture of Demetrion Garlington, and next to the picture of my client, Shannon Stillwell. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had 2 small problems. First, you will see the surveillance video. You will be able to watch the surveillance video and the lighting conditions out there and the fact that there's gunfire going every which way and how fast the car is moving. And you will be able to judge, was it ever even believable that someone could see 4 people inside a car under those conditions? But there was a bigger problem that Detective Thorpe had. You see, you'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe. There was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there who just signed those photo lineups that just helped our case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright. So, the case was solved by someone who lied about their name. So, what was Detective Thorpe's solution? Well, this is what the evidence would show. Detective Thorpe completely overlooked the lie about the improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or he said to Spencer Wright, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again, and instead of writing a fake name, Nicholas Robinson, could you actually sign your real name, Spencer Wright? And Spencer Wright did. So what happened? Detective Thorpe, on October 19, 2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson, Detective Thorpe took out warrants for Antonio Sledge, Demetrion Garlington, Kenneth Copeland and my client, Shannon Stillwell, based on what Spencer Wright said. Okay. Since October 19th of 2015, people have had an opportunity to review some things on this case. The surveillance video that you will see, it's interesting because not only does it show me Daniel Street to catch the incident, but it also shows the Marta park bench right across from the barber shops on McDaniel Street. And know who's in the know who's in the park bench? The bus Marta bench across from the barber shop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here. I'm inserting myself into a case so I can get favorable treatment so that others get arrested. The state has since dismissed the charges against Antonio Sledge, Kenneth Copeland, and Demekion Garlington. They continue to push forward against Shannon Stillwell. Why is Spencer Wright so important? Why have I spent so much time talking about someone who clearly lied, who clearly wasn't there, who clearly made things up? Well, Spencer Wright gives us the blueprint. He tells us what to look out for. What was Spencer Wright wearing when he fabricated his story? Fulton County blue. What did he want? What was he in search of when he fabricated his story? Control of his destiny. He didn't want it to be left in the judicial system. He wanted to use something to get a deal. He wanted to take back control. That's what Men in Blue do. Okay. In this case, I anticipate the state will bring 4 witnesses forward. All 4 have certain things in common, as I stated. When they supposedly came upon information that was relevant, never shared it with law enforcement. But once they were wearing blue and they needed something, that's when they came up with their stories. I anticipate the state will call Quindarius Zachary, ironically, one of the people accused by Spencer Wright. You'll learn that he claims he knew information from January 10, 2015. January, February, March, April, May, never shared this information with anyone. But lo and behold, you'll hear he found himself in custody for serious charges on August 5th of 2015. Then all of a sudden he had a story to tell. You'll hear he gave a second statement to law enforcement approximately a year later, where he was in a room with the gang investigators, with prosecutors, including the prosecutors that were handling his case and had control over his destiny, his future, and his attorney. And you'll hear that he gave a second statement and was looking for a deal. Quindarius Zachary is no longer wearing blue. Quindarius Zachary is not charged in this case. He got his deal. You'll hear about Kenneth Copeland. Again, someone ironically accused by Spencer Wright. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for guns, found in possession of guns. October 28, 2021, guns, found in possession of guns. And he makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes through the same song and dance about how he'll do anything, just don't don't make me wear that blue. Kenneth Copeland is no longer wearing blue. And he's not charged in this case. I anticipate you may hear from a man named Sammy Davis who claims he was at the scene on January 10, 2015. January through December 2015, never once went to law enforcement. 2016, never once went to law enforcement. But then in March 17, 2017, when he's in jail wearing blue, law enforcement comes out and talks to him. You'll hear his story. His story about how 2 cars were driving down McDaniel Street, and the first car sent a signal to the second car saying Donovan Thomas is just leaving the barber shop, as a signal like it's time to shoot. And how the second car pulled up in front of the barber shop and stopped in the middle of the street. Just stopped. And then people started shooting at Donovan Thomas. You'll hear Sammy Davis' story. You'll also see the video. You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barber shop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis' claims that this car stopped are 100% wrong. The car never stops. The car drives on by. Bullets flying everywhere. You'll be able to listen to Sammy Davis' story and compare it to the surveillance video to figure out how much value you should give his story. And finally, I anticipate you may hear from a man named Tremont Stillwell. A man who curiously claims he's my client's uncle. Not sure what that's about. You'll hear that he claimed to come across important information in January of 2015. And he claimed he came across this important information while talking to someone with his wife, Vanetta Guffey, right there. You'll hear throughout all of 2015, never said a word to law enforcement. Wasn't until March 22nd, 2016. Guess what color Tremont Stillwell was wearing at that time? You got it. When he was in jail for serious charges, and he needed help. He needed help from law enforcement to start to reclaim his destiny, control over his life, to escape the monotony and the filth of the Fulton County Jail. And you'll hear that he claims to have information. You'll hear that the state, to their credit, went to try to corroborate whatever Tremont Stillwell was talking about and talked to his wife, who is now deceased. Her name is Vanetta Guffey. She is now deceased. But you'll hear that she was interviewed on May 11th of 2016 when she was still alive. And you'll hear what she had to say about Tremont Stillwell's claims. That what he's saying happened, never happened, A, and that Tremont Stillwell is a effing liar. Those are the state's witnesses in this case. Those are the men in blue. Count 2 of this indictment is the count that charges my client, Shannon Stillwell, along with a whole new group of individuals, with the murder of Donovan Thomas. There will be no forensic evidence, there will be no ballistic evidence. There will be no eyewitnesses that presented themselves at the scene to say, I saw this occur. The surveillance video will not give insight as to whether Shannon Stillwell was there or not. The state's case will rest entirely on the word of men in blue. When the evidence is done and trial is done in this case, I'm going to ask that you return a verdict of not guilty to count 2, murder. Okay. Hold on one second, Shane. Now, I would like to preview a little bit about my client's life after the Donovan Thomas murder. Remember, on October 19, 2015, the Atlanta Police Department, Detective Thornton, and the news broadcast to the world, and more specifically to the streets, and more specifically to the Inglewood family blood gang that Donovan Thomas was the head of, that my client was responsible. Based on the word of Spencer Wright, based on the word of someone that even the state is saying lied. First they said wasn't completely accurate. No, it was a lie. Based on that, they broadcast to everyone that my client was responsible. And there has been repercussions. You'll hear in 2015, people pulled up to my client as he stood outside his store, shot a gun at his head, and grazed his forehead. Thankfully, he's still with us. You'll hear that later in 2015, my client went to go get a fish dinner with the mother of his child and another young lady named Tiara Jones at JJ's Fish at the corner of University and Pryor. And members of the gang spotted them there, stalked that car, drove behind the car, and unleashed bullets upon that car, hitting that poor lady, the driver, Tiara Jones, in the face, killing her, causing the car to crash and spin, breaking bones in my client's body, collapsing his lungs. The streets have not cared that Spencer Wright is a liar. Since that time, my client's life is changed in some small ways and some big ways that I think make sense. Shannon Stillwell, since that time, has been careful about his surroundings. He tends to back into parking spots. He tends to run red lights at intersections, not to be a sitting duck for IFA members or anyone else. He habitually changes residences. And yes, he does habitually rent cars, including a white Audi. He does this, the evidence will show, so no one can associate him with any particular car. None of the IF gang members can know where he is. And yes, when he rents cars, he does tint their windows so no one can see in. That's the life he leads since 2015. And yes, when he leaves the house late at night, he does conceal his identity. It was during COVID, but he does wear a mask. That's been Shannon Stillwell's life since 2015. And I'm going to ask that you keep that into account as you consider the evidence as it's presented. Now, 7 years later, March 14, 2022, remember, Shannon has been publicly accused, but no one has ever taken that case to court. No one has ever even tried to actually prove the case. They just accused the case. And Shannon has remained a wanted man. Not by the police, but by someone scarier. On March 14, 2022, the evidence will show that Shannon, Marvius Nichols, Nikion Garlington, and Miles Farley were planning on going to the music studio to work on music. Still chasing after. The evidence will show that Mr. Garlington was a passenger in Mr. Stillwell's and Shannon's rented white Audi with tinted windows, and Mr. Nichols was with Mr. Farley in Mr. Nichols' white Ford Fusion. The evidence, and you'll see, in this case, you'll see there's several different surveillance videos that you'll see in this case. The first being the BP footage. And that's from the BP at the corner of Fulton Street and Windsor Street in Atlanta. And you'll see the video. And you'll see Mr. Stillwell. No, we will never deny that he was at the BP. We will never deny that. We'll never deny that he was in a rented white Audi. And you'll see Mr. Stillwell pull up on that camera and back into a parking spot right in front of the BP. And you will see Mr. Nichols shortly thereafter in his white Ford Fusion pull up at the gas tank so he can purchase gas to get to the studio. You'll see footage from inside of the store. That's Mr. Nichols. You'll find out that that's Mr. Nichols purchasing an item, and that's Mr. Stillwell, my client, wearing a Pink Floyd hoodie with a pink wool cap on. And you'll be able to observe them on video, and you'll see Miles Farley, a third person in their group, a shorter individual, come in, and you'll see them playing around and pushing each other in a playful manner as friends do. I'm going to ask you to observe them on a video and ask yourself, does that appear to be men on a mission? Or does it appear to be friends just planning on going to the studio? The video will reveal that at some point, a gentleman by the name of Shamal Drinks pulls up in a red car at another, in fact, I believe that's a picture of it right there at that gas pump, and he enters the store. You'll be able to see the video of him entering the store from the parking lot, and you'll be able to see him inside the store. You'll see that he gets into some sort of argument or altercation, not an altercation, an argument. It appears with the clerk, and he leaves the store, and he gets in his car. There will be no interaction whatsoever between Mr. Drinks and my client, Mr. Drinks and Mr. Farley, Mr. Drinks and Mr. Nichols, Mr. Drinks and Mr. Garlington. There'll be no interaction at all. And you will see Mr. Drinks exit that parking lot and take a right on Windsor Street. And then you will see Mr. Stillwell exit that parking lot and take a right on Windsor Street. And then you'll see Mr. Nichols exit the parking lot and take a right on Windsor Street. And that's where the FedEx surveillance footage will take over. And you'll be able to watch the FedEx footage on Windsor Street, which will show these cars drive up and end up at a red light. You will see my client's car, white Audi, run a red light. You will see Mr. Nichols follow my client's car and run a red light. Eventually, cars come in to replace him, and traffic flow continues and continues for several minutes. And eventually, a man who's just happened to be going the other way looks into Mr. Drinks' car, which is still sitting there, and notices that Mr. Drinks has been shot. What you will not see on this video is any indication at all that this shooting occurred while my client's car was beside Mr. Drinks. You will not see any muzzle flash, you will not see any commotion, you will not see any fight, you will not see anything at all that suggests that that's when the shooting occurred. So, this March 14, 2022 case, what I anticipate is you will not hear any eyewitnesses say that Shannon Stillwell, and let's be clear, the state is accusing Shannon Stillwell. I mentioned that there's 4 people in this party. They are accusing Shannon Stillwell of shooting Mr. Drinks out of that white Audi. The state will not present to you any witnesses that saw this occur. The state will not present to you any forensic evidence that proves that this occurred. The surveillance I submit to you, and you'll be able to see it and judge for yourself, points to the exact opposite, that the shots did not come from Mr. Stillwell's car, nor did, and I'm not suggesting they came from Mr. Nichols either, they came from neither car. So why was Shannon Stillwell arrested? Well, they had video of Shannon at the BP. Okay, that's fine, we don't deny that, never will. They made certain assumptions about what would be on that FedEx video that you will be able to look at and determine what it shows and what it doesn't show. And I'm sure they assumed that it would show some shooting, but it doesn't. And finally, they made assumptions about Shannon Stillwell. Remember what the state said in opening about how Detective Hogan had his case. He had people on a video at the BP, which is near where the shooting occurred, but not where the shooting occurred. He had people on his video, and then he talked to another detective, Viverito, and Viverito said, "Oh, that's Shannon Stillwell. That's Shannon Stillwell. Oh, that's Marcus Nichols." And they just ran with it. Yeah. Shannon Stillwell was at the BP that night. He didn't shoot Shamal Drinks. None of his friends shot Shamal Drinks. They went to the studio. Since these warrants were taken out for Shannon Stillwell, and I'll tell you the warrants were taken out and Shannon Stillwell was arrested in that same white Audi on March 17, 2022, 3 days later. Since those warrants have been taken out, some other information has come forward. First, I'm going to ask you, and this will be entered into evidence, I'm going to ask that you consider the rental agreement for the white Audi. You will learn that on March 16, 2 days after this alleged shooting, when every other person who has a guilty conscience, anyone who has a guilty conscience is trying to get out of the rental car, Shannon extended his lease. I'm going to ask you to consider and really think about that. Extending a lease of a car that you supposedly just killed someone. Are those the actions of someone who's guilty of that crime? You're going to hear about the wiretap on Demekion Garlington's phone. Remember, Demekion Garlington was in Mr. Stillwell's car. And the state hinted at it a little bit. They were talking about Jaden Myrick and people wanting to attack a man named Lucci. And based on these concerns in the jail, the state applied for it, and you'll learn what a wiretap is. They applied for a wiretap and received a wiretap for Demekion Garlington's phone. The phone of the person who was with Shannon Stillwell on March 14, 2022. And you'll learn what a wiretap is. and how a wiretap really consists of law enforcement sitting and listening in on all your phone calls, incoming and outgoing, and recording all the relevant and pertinent phone calls and conversations that occur. You'll learn that this wiretap on Demekion Garlington's phone began on March 10th, but certainly well before March 14th, the date of the Shamal Drake shoot. So it was in place that night. Who knows about the wiretap? You'll learn that too. Do you think the government tells you that your phone is being wiretapped? Of course they don't. It's secret. No one knows. That's the point. And you'll learn about who Demekion Garlington is and what type of guy he is. I would submit, if you have a secret, you wouldn't want to tell Demekion Garlington. You'll hear him on the wiretap, drunk, high, talking about everything under the sun. Pills, weed, guns, girls, robberies, all stuff that he's involved in, completely against his interests to discuss, but he doesn't know he's being listened to now. But one thing that's interesting, of all the things that this loudmouth talks about, all the crimes, and they said they bragged about this stuff. They said Demekion Garlington was bragging about this stuff. All the things they brag about, no, it never comes up. Shooting anyone on March 14, 2022. All the crimes he discusses, that never comes up. Finally, and most importantly, the science about this March 14, 2022 case. We're going to learn about gunshot residue. Gunshot residue testing that tests for microscopic particles that contain a combination of lead, barium, and antimony. Particles that come from the explosion of a gun and the gunshot primer that causes it. Synonymous with a firearm that has been fired. Who does gunshot residue testing? Georgia Bureau of Investigation, APD, all sorts of agencies to build cases against defendants. You'll learn how gunshot residue is collected. How you take a surface or a body part or an object, and you take these adhesive stubs, these official gunshot residue kits, and you dab the surface of an item as much as you want. You can use multiple stubs. And then you take these stubs and you place them under an electron microscope. And a scientist can look under this microscope and see if there's any particles of gunshot residue that are on said item. You'll hear that Shannon Stillwell was arrested on March 17th in that same white Audi that he was in on the 14th. And you will hear that the crime scene technicians, in this case, made a specific decision to pick the best place on a car to test for gunshot residue. When the gun is fired, the gunshot residue would plume upwards. And so they take the best part of the car, the headliner. And for all of you that don't know what the headliner is, that's the cloth top of the car. As pictured right there. You'll hear about Alexander Coven, a scientist, a man in search of the truth, a man who works for GBI, not for me, not for Shannon Stillwell. And you'll hear how that headliner that was collected from that white Audi on March 17th was brought to Alexander Coven at the Georgia Bureau of Investigation. You'll hear he's an expert in gunshot residue collection and analysis and detection. And you'll hear how Mr. Coven, as he was trained, took that gunshot residue kit, and took those adhesive tabs, and dabbed that headliner again and again and again and again and again and again. Dozens of times. And then he wanted to make sure what he did was sufficient. So he took a second tab, adhesive tab, a fresh one, and continued to dab that headliner again and again and again and again and again to pick up any particles that would be on the headliner from that white Audi. And he took those tabs, those adhesive tabs, and he put them under his microscope that he uses when he's building cases for the state. And he looked at those tabs under that microscope for any particle of gunshot residue, any at all. Looking for 15, 10, 5, 3, 1, whatever he could see. And you'll hear that on June 3rd, 2022, 77 days after the state, after Detective Hogan, Investigator Viverito, and the state made their decision that Shannon Jackson fired a gun, Shannon Stillwell fired a gun from that white Audi. 77 days after they made that decision, you'll hear that scientist Coven released his report. And on that headliner, there was not a single, zero gunshot residue to be found. That's the science. Ladies and gentlemen, regarding the March 14, 2022 case, the state has made 5 charges, 5 different counts against Shannon Stillwell, my client. First is count 49 on this indictment. It is murder, alleging that he shot out of the white Audi, and shot Shamal Drinks. The science belies those accusations. I'm going to ask you to find Shannon Stillwell not guilty of that count. Now, count 50 and 51 deal with violations of the Criminal Street Gang Act, Gang Activity Act, and they are essentially charges that say that Mr. Stillwell committed murder to further the interests of YSL, and he committed murder on behalf of YSL for the purposes of increasing his standing within the gang. Y'all are smart people. Obviously, I don't need to say it, but it'll make me feel better if I say it. If he's not guilty of count 49 murder, he cannot be guilty of count 50, and he cannot be guilty of count 51. Counts 52 and 54 similarly charge Shannon Stillwell with possession of a firearm by a convicted felon on March 14th of 2022 on the belief that he used a firearm to kill Shamal Drinks. If the state does not prove that case beyond a reasonable doubt, he cannot be found guilty of count 52. And count 54 charges Shannon Stillwell with possession of a firearm during the commission of a felony, that felony being murder. Obviously, if he didn't commit the murder, then he cannot be in possession of a firearm during the commission of said felony. In conclusion, my client has been charged with 2 separate murders. He's been wrongfully accused of 2 separate murders, and we plead absolutely not guilty. He's been charged with conspiracy to violate the RICO Act. And while he has sold marijuana in the past, those were his decisions for his benefit and had nothing to do with YSL or anyone else involved in this case. He's pled guilty to those charges. He's done his time. That makes him an ex-drug dealer. It doesn't make him a conspirator. It doesn't make him guilty of violating any RICO acts. The ground rules. Shannon Stillwell is presumed innocent. The state bears the burden of proof. and the standard of proof is beyond a reasonable doubt. I believe in this case, if you focus on where the state's evidence comes from, you will find that primarily it comes from the stories of men wearing blue. I'm going to ask you to focus on things like science instead of stories. Compare the credibility of a scientist like GBI scientist Koval, who followed all the rules and determined there was absolutely zero gunshot residue in that outfit. Compare that to what the state presents. Spencer Wright, who said his name was Nicholas Robinson, who lied to get out of jail. Spencer Wright duped Detective Thorpe on October 19th of 2015, and that is on Detective Thorpe. I am going to do my best to make sure that the truth comes out in this case. Make sure that no one wearing blue will be able to dupe anyone during this trial. My client, Shannon Stillwell, is not guilty. Thank you very much.
Ladies and gentlemen, how you doing? It's 5:30. All right, consistent with my earlier promise to see you, I think it might be a natural stopping point for us to put a pin in today and for us to come back to more, unless you all object to my suggestion. Hearing no objection, I think we're going to go ahead and do that. So let's go ahead and kind of review a couple of things to begin with. All right, first thing is when you go back into your headquarters jury deliberation room, dump your notepads, okay? Hopefully everybody's written their name in the inside cover of those particular ones like I told you earlier. But if you haven't done so, go ahead and do so. Take a juror sticker and put it in your pocket, your purse, or whatever carrier device you have, so that when you come back in tomorrow morning, we'll go ahead and you can put that on as soon as you get into or clear, as you come in through the being screened in the courthouse, okay? All right. You kind of figured out already for tomorrow, if you need, and I think I mentioned to you this earlier, a lot of you wearing jackets and everything else, it's easier, like I said, for you to put on a jacket or for you to take off something than it is for me to kind of regulate the temperature. So please bring whatever it is that'll make you comfortable tomorrow, your jacket or otherwise. Okay, that's kind of the ministerial. And if you're running late tomorrow, as I mentioned earlier, let Ms. Umana know. But remember, I can't start until I've accounted for all 18 of you. So it's very important you, again, as I mentioned earlier, only you know how long it takes for you to get down here to Fulton County from wherever you live in our great county. So just plan accordingly, leave a little bit earlier. It's always easier for you to sit back there and just kind of relax and don't be so stressed than it is for you to kind of leave late, and that just kind of just puts you in kind of a position that you probably are stressed already when you get here. So I'd advise you to do that. Okay, you remember all my ad nauseam admonitions? They still apply, okay? So, very important, I mean, that you not talk about the case amongst each other as you're walking out. Do not talk about the case as you're in your headquarters jury deliberation room. Don't go on any social media sites. Do not let anybody friend you. Do not do any of the other things that I've told you earlier, like research anything, go by any scenes, take any photographs, or otherwise try and educate yourself to some things that you may have heard in the courtroom today. Remember, the only things you can consider are what's lawfully presented within the four walls of this courtroom. So it's very important that you consider and keep the court's admonitions, which I know you will continue to do so. There is great temptation when you go home tonight. Hey, what happened in court? Well, I saw you on TV. Are you supposed to respond to that? No, you're not. And you can blame me. You can even tell Judge Glenville said for you not to do that, all right? Because remember, your doing that would affect, and if we found out about it, would affect our ability to have a fair trial, a just trial, lawful trial as to all parties. So please adhere to that admonition and all the others, okay? Remember, nobody's supposed to have any ancillary or incidental contact with you. If anybody tries to reach out to you, I need to know about it so you can tell Sergeant Ingram or any of my team if anybody should try and do so, okay? And consistent with my instructions when you were here before, we'll go ahead and get you squared away for those of you that are taking the shuttle and for those of you that need to make other alternative arrangements. We have just get with Sergeant Ingram. He'll go ahead and coordinate that for you, okay? All right, so you're probably wondering, what time are we going to start tomorrow morning? I need you all here to be here by 10 o'clock, okay? We will start somewhere between 10 and 10:30 tomorrow morning, and I'll do that, try and give that to you every single night that we conclude, tell you what time in the morning you need to come to be here. That's your target or mark time you need to be here in the morning. Try and get here a little bit earlier because then, like I said, you'll be a whole lot more at peace. And then as soon as we, at 10 o'clock or thereabouts, I can find out if all 18 of you are here and I don't have to look for anybody. And then I can go ahead and we can get started once we're ready to pick up from where we left off from today. Okay? So, 1,000 hours tomorrow, you need to be in your headquarters. Okay, I think I've gone through all the things I need to with you. Any ministerial inquiry of me at this point in time, ladies and gentlemen? Anything from me? Questions? None? Okay. Ladies and gentlemen, thank you for your patience with us. And as I mentioned earlier, and I mentioned through this entirety of the process, the patience that you've given us, are giving us today, and will continue to give us throughout the consideration of this matter. So unless you have any other query or questions for me, I will release you until tomorrow morning and bid you comfort, and we'll see you in the morning. We'll start up when you all get here at 10:00 hours, okay? All right, so with that, ladies and gentlemen, have a good evening. All rise.
Ms. Taylor, to you, Mr. I made eye contact with you and asked you to please stop talking during all that. Please don't do it. Yeah, you just stop all this. I would
Okay. You want to pick one up?
Okay, ladies and gentlemen, please be seated. Our jury has left us and the door is closed. All right, so, counsels, tomorrow morning, first, before I go ahead and set the time for you all to be here tomorrow morning, Mr. Harvey, sir, have you talked with counsel for your client? Your client's spouse, I should say.
No, I haven't, but I can, and I will start a contact her. She was flying back in after the holiday, so I did start a contact her. I'll do that right now.
All right. If you could ask her to be present for at minimum 9:45-ish tomorrow morning, I'll take it up somewhere between the 9:45 and 10 o'clock time period, and I can go ahead and get that done, or you can have a conversation with the state and I can final that particular ruling, okay?
Yes, sir.
All right, okay. So, counsels, if you all could be here tomorrow morning for approximately 9:30, when, as I told our jurors, as soon as all of them are accounted for and we take up that last issue, then we'll go ahead and get started. What questions do you have of me? Anybody?
On behalf of Mr. Williams, sir.
Okay, so Mr. Steele, you have yet to make an opening statement, is that correct?
Correct.
All right. Mr. Matthews, you have not made an opening statement as of yet?
That's correct.
Ms. D. Williams, you have not made an opening statement as of yet, is that correct? All right, is there anybody else that I have not taken into account already?
Michael.
I'm sorry?
Michael.
It's just going out, that's all. You know. Yeah, it's kind of giving up on me today. I don't know what's happened to it, but yeah. Anyways, Mr. Happ?
Just that we would get over and say.
Okay, all right. So we'll start tomorrow with that, and then I anticipate after we complete opening statements, stating you're prepared to call your first witness?
Yes.
Okay. All right. Any other inquiry of me at this point in time? Okay, hearing none then, folks. Appreciate your patience and diligence. I'll see you all tomorrow morning for an anticipated 10 o'clock start time. Please try and be here by 9:30, and then we'll go ahead and I'll take up Mr. Harvey's matter, and we'll go ahead and get started, okay? All right, we're in recess.
Thank you, Your Honor.
You're welcome.